Welcome back. It helps if I can turn my mic on, huh? Welcome back from lunch. A little bit break, a little early lunch, right? I think we're going to work through lunch today, like the actual lunch time. We've got a lot of stuff to follow up on. We've got the extreme skier trial, or better known as New Mexico versus Dean Cummings. We're expecting back in about 6 minutes. That's the timer. I'm going to go ahead and clear that timer off here because we need that timer for some other things like this right here. It's the same engine that drives our chat. So looks like this early afternoon or early, I guess late morning, Fairy66 is first in chat saying, hey, emoji, 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 emoji. British flag, sunflower smiley face, love, or is that hang loose? I can't see from here. Anyway, it's thank you, Fairy, for that little chat. And with that chat, because you were first in chat on this live stream, you take over ownership of the internet for the rest of the afternoon. So congratulations on that. We will pack it up in some packing peanuts, tape it up, and ship it to your house. You'll be responsible for everything internet-related worldwide until we go live again. So thank you for taking on that responsibility. As we're getting ready for Dean Cummings, for the closing arguments, really is what we're waiting for first. So we're getting ready for that. Just want to put a shout out. If anybody would like to, if you've got something on your mind that you want to get off your chest and get on the air, you can reach me at my burner phone. The burner phone number is, I'll put it here in chat and I'll highlight it here. Just 1 second. If I can remember the number, this would be a bad time to have a typo. Some poor soul would get bombarded with your calls. That is the burner phone number for the Recovery Addicts Hotline. If there's something, Donna says, I need to get this off my chest. Yes. Give that call a number, or give that number a call even. That would be better. And let me know. You can text it. You can send pictures. If you have your mug that's delivered and you want to show off to everybody else exactly how amazing it looks to be drinking out of an official Recovery Addict, True Crime Addict mug, you can text a picture of that as well, and we might be able to put that on there as well. Donna giving us a little too much information. My dog peed on my wall. She needed to get that off her chest. Bummer, man. Dogs, you love them, though. They're amazing. Let's see. Anything else? If you have something you want to say about the trials that are coming up that we're watching, or it's the ones we're not watching yet, I think just in the break, I was watching this Matthew Terry trial, which has like a million different names, right? It's Matthew Terry versus fleeing girlfriend, or it's not versus, but Matthew Terry, the fleeing girlfriend, or the math teacher murder. A whole bunch of different things in there. It's got some pretty interesting elements. Obviously, a murder's involved, which is a common element. We seem to find those in these trials. But you've got a defendant who was found with a search with dogs and everything in his underwear in the woods, covered in blood. Got some strange stuff there. So this Golden Mom says the Matthew Terry trial is interesting. If Dean Cummings is wrapped up today, if the jury comes back and says not guilty, we'll be talking about Matthew Terry tomorrow for sure. That's where we are. Donna, welcome. Fairy, Ann, Shauna, Paula, Bernard, Last Poet, Laura, Seven. Yeah, I think that I got most of you that have typed in chat, but we're still getting ready. We've got just about 2 more minutes before the before we're expecting the cameras to turn on. This judge has been pretty prompt, so hopefully it starts as soon as that happens. Let's see. Mr. Opetorso said, just dropped in from catching up on Matt Terry. The defense is thin, in my opinion. Yeah, for sure. Still prosecution, though. Prosecution's still presenting their case, so we'll be able to catch up on that one and get everyone up to speed. Seven said, this is my new favorite live stream to listen to while being a mailman, so thank you, Seven. Rain or shine, the mail must be delivered. You are amazing. I have always, ever since I was a child, I've loved getting mail. As a matter of fact, I loved getting mail so much. My parents can vouch to this. I signed up for every type of free mail you could get. So I was getting the Publishers Clearinghouse sweepstakes mail things long before I was eligible to even win the Publishers Clearinghouse sweepstakes. Catalogs. I had land offers from Montana, buying land, you name it. If there was somebody that had something free, they would mail me. I signed up for it. So I kept the mail employed in my youth. And now I'm not as big a fan as junk mail, but I still look forward to the mailman who still walks up at our house. We have our mailbox right in our house, walks up to the door, and a lot of times my kids will see him come in and run and open the door and get the mail and say thank you, and it's just really neat. I've always liked mail deliveries, so shout out to you, Seven. Appreciate that. Let's see. Yes. Trump and Brooks on November 15th. Kind of want to go to the courthouse and watch it, says Golden Mom. Are you close by? Is that an option for you? Could we watch you be live in the background? And we're back, says Churchy. Yes, Matthew Terry and trial, very interesting. Yes, we're probably picking that up tomorrow, depending on what happens with Dean today. Maybe the defense is hiding an ace in their sleeve, but their opening didn't really hint at anything. I think it clocked in at 3 minutes. Wow, what are they hoping for? Just like a sympathy vote? That he's a real person? I was watching and they were talking about on the cross about how bloody and pale he looked when they found him. But by my timer, judge is due back right now. So I'm going to go ahead and clear the timer off. I'm not going to count how late he is, but we'll have him back here in a minute. Sandy Fields watched a little Matthew Terry, not the same without the group. We'll be there tomorrow, Sandy. I think this is really going to wrap up today. As long as the judge doesn't, we're getting a late start today, but if we can do closing statements, get the jury charged, get them deliberating today, and have a quick verdict, it might be over before dinner time. So, Katrina with the late crew sliding into the back pew, late as usual. Welcome. We saved a spot for you back there. Oops, sorry, some typos. Fat thumbs on the smartphone. Hey, that happens to me all the time. Only sometimes I use the voice, the speak to text feature on my phone. And for being a smartphone, it oftentimes is not smart in translating what I said into what I meant. And I've said a few things that I had to apologize for and explain that wasn't me that typed that. That was my phone putting words in my mouth. I like the judge in Matthew Terry trial. Have seen him before. No nonsense, but very fair. The trial is brutal, 100%. Okay, so keeping an eye on the feed. They're late. That's all I can say. 2 Cents says, good morning. How is the computer today? It's bright enough now that I can't see the backlit keyboard. I can't tell, but I know that there are some letters like the B button. You have to really want to use the B button to get it to type the letter B. The G, the H, the 9, the N, they don't light up anymore, but they're working. So far, so good. Okay, I need to catch my breath. I played that music and I'm looking at all these court feeds up on my screen and I'm like, I just need to let it out. Okay, relax. This is going to be great. Trying to follow everything at the same time. Oh, here we go. We've got a feed. Just barely. We haven't missed a single thing. So let me get this set up with that. Okay. So I'm going to cut to that first and make sure we have audio and we're good. Okay. All right. So we're waiting for the judge to come back to the courtroom. The feed just barely turned on. We have not missed anything. Yeah, there's no docked points for spelling in here. If I can understand what you meant to say, it's good enough. Just getting on this morning. What did you miss, Franco? Not a lot. We just caught up from this morning, talked a little bit about yesterday, reminisced a little about particularly the prosecution and whether or not it was wise for them to put the defendant up on the stand. Here, I'll bring out this picture and show you. Boom, boom, boom. Right there. This was what we talked about. It was bizarre. It was the most bizarre moment I've ever watched in a little reenactment. But Dean had the gun. Here we go. We're coming back. Hang on.
Yes, Your Honor. We proposed, two rebuttal witnesses. One would be Sergeant Griffin.
Okay, so we don't get closing yet.
Put in context, not in detail, but the fact that these incidents that the neighborhoods testified about was an ongoing neighbor dispute. He called on them as much as they called on him. And the other thing was that when you responded to these calls, did you get both sides? Were there differing accounts of what happened? Yeah.
So first of all, there's a bunch of hearsay that can't come in there. So she wants to call a police officer. He didn't get called to every incident. He only showed up 4 or 5 times as the sergeant. So he can't talk about all of the incidents that we have police reports for. The court didn't allow us to have our witnesses talk about the ongoing neighbor dispute. So if the court doesn't allow us to get that testimony out of our witnesses, how is it now appropriate for the state to call Sergeant Griffin to say this was an ongoing neighbor dispute? It went back and forth. Sometimes Mr. Ariola called. Sometimes the neighbors called. If the state gets to do that, we get to put our witnesses back on. They can talk about how they were shot at, how their elderly relatives were called a cunt.
Okay, I apologize for the language.
Let's get into it. We weren't able to.
Your Honor. Are we on the record yet?
No.
Oh.
So
we're on the air, though, so please watch your language.
No.
All right. Well, Your Honor, as I recall, you restricted what they could say pretty well.
You can be seated.
And on cross, Ms. Walker attempted to say, was this a dispute between both of you, whatnot, and they denied it. They acted like it was all Mr. Gurriel.
I'm not going to allow Officer Griffin to testify on that. It was my ruling was very limited. It was limited only to show that defendant had mace and used the hammer. That was it, and that's all I allowed.
So in terms of the other witness that Ms. Romo wants to call, she wants to call Tomlinson, who went to the scene, I suspect, for the very first time on October 28, 2022. 2.5 years after the incident, took photographs of the scene, which were just provided to us a couple days ago. Even though the pictures were taken on the 28th, I don't think we got them until the 3rd or the 4th. So
Did you just clear her throat
new
with the microphone?
evidence that shouldn't come in because it was provided after trials started. And then she wants to ask him questions about when you submit items to the lab for testing, how do you decide what to send? That testimony is already in evidence. He's already testified to when he sends things to the lab, what happens. Quite frankly, his testimony is wrong, and his testimony is going to be wrong when he takes the witness stand again.
Ms. Romo, and we're not on the record.
I'm sorry?
We're not on the record.
Okay.
Okay, all right. So.
Judge, first of all, yes,
I love
Frank
that they give us
Tomlinson,
this off the
Sergeant
record.
Griffin, and myself and co-counsel went to the scene in response to their demonstration and their expert's testimony, which was provided late.
This is prosecution right
with the specific
here.
purpose of seeing if what he was saying made sense in the parameters, giving everything, the room and whatnot.
They're arguing for rebuttal
as
witnesses.
I think it was Ms. Moss who pointed out so eloquently last week, we don't have an obligation to provide demonstrative rebuttal evidence, and that's all this is going to be, is demonstrative.
Your Honor, there are photographs taken 2.5 years later of Tomlinson standing in the room like this, trying to demonstrate the size of the room, and you can't even see where this hand is. They didn't even take the pictures right. Not to mention the fact that they're photographing a scene that's 2.5 years old.
I'm sorry, that slipped through, Tom.
Hang on.
I'm not finished. Hang on.
They want to have him show a picture of the mirror that was hanging on the wall. We don't know how that was changed over the last 2.5 years. I'm sorry their lead detective didn't go to the scene for 2.5 years. This doesn't come in. This is ridiculous. He can't show a picture and talk about a mirror that was in the room on October 28th, 2022.
There's other things he can talk about, Judge. For example, and I know I asked at least 2 witnesses about that drywall. That drywall, I think one of the experts said, well, it could be firm or it could not be firm. And the point of that is to rebut the testimony that there was a struggle in this little room, and also to rebut the inference that was made yesterday in front of the jury by Ms. Moss that we just made this up, I guess. No, we measured it. It's accurate. And it's relevant to whether there is a struggle in the room. You can push on that drywall, even a little bit, it bends. It's very thin. And the likelihood of a struggle taking place in there.
Yeah, but Ms. Romo, what I'm saying is this is more collateral than rebuttal.
You're grasping at straws.
How? I don't understand what do you mean collateral?
You're just adding more. You're not rebutting what they say. You're just adding more to what your side brought forth.
That's exactly
I don't even know, for example, I don't even know, for example, if that heater now is back on the wall where it was.
The heater's
Is it back on the wall?
We're not going to show it back on the wall, Judge.
The heater's back on the wall.
Hold on.
And, moreover, the point is the pictures that are in evidence, they can see those pictures and the items that are still there, as in the pictures that were taken in 2020.
But that's not the question. The question is, my question, for example, that heater, is it still in the very same position it was the day of the... no, now it's hung up.
On the wall.
I'm not showing that heater. I'm not rebutting that. And I'm also... Another thing I'm going to rebut, Your Honor, with Mr. Tomlinson or Sergeant Griffin, the defendant got up there and said that bathroom is not right across the front door. It clearly is.
And she's already shown a photograph to demonstrate that. Yes, you have a picture in
It's already
evidence.
that's been established already.
Yes.
I'm not going to... This is all collateral, and it's changed so much, and I'm using the example of the heater in that if it's changed since then, what else has changed since then?
And this is also in rebuttal to their experts saying that all crime labs can do certain kinds of testing, which is not true. Our crime lab does not do, for example, they don't do residue testing. They don't do chemical testing.
Well, who knows that? Does Mr. Tomlinson know that?
Yeah.
Your Honor, he didn't testify that all crime labs can do everything. He actually testified that the mace, in order to test something for mace, would have to be sent to an outside lab. That's what he testified to.
Well, Judge,
Now, the state's got themselves in a difficult spot because the ballistics investigation in this case was pitiful.
Amen.
Absolutely
Okay,
pitiful.
I'm not going to allow any of that as truly rebuttal. It's collateral. It's out. The photos are
So we might not get any rebuttal
Judge,
witnesses.
recent.
can we not make an allowance for the fact that they gave it to us at the last frickin' minute? We went out the same day they gave us their demonstrative evidence to test it. And he's going to
He's
testify.
not qualified to test anything.
He's going to testify about his observations,
When?
and that testimony will be used an argument.
Hold on. Testimony of when? He wasn't there until what, recently?
October 28th.
But Judge, some things are not going to change. And the
How do we know?
that Ms. Moss implied that John made up was an accurate measure from that scene. And
What?
that's important. That's important in this case, Judge. That room was so small.
Well,
Then listen, here's the problem. The problem with what they're trying to do is this man was out there on October 28th.
I already made I'm not going to allow it. It's shown right there how small that room is.
He
We
was
don't need any
out
more
there
of
on the
that.
28th.
Okay.
They could have asked him when he was on the witness stand, and they didn't.
Because it would, there wouldn't have been, there would have been an objection.
Sure,
Because
yeah, I
it,
understand.
excuse me.
Excuse me.
Because it is rebuttal evidence, rebuttal demonstrative evidence, which you will know and they will know I cannot present until it's raised by defense. And it was strictly for rebuttal. And they
Absolutely
argued
not.
so eloquently at their motion hearing that they do not have to provide demonstrative evidence,
But we did.
but we did too.
Okay.
And they're saying we didn't go out to the 28th. Well, they didn't get to do the second interview till the 28th.
But this isn't rebuttal. That's still the baseline problem here, is that this is not rebuttal. And there's no reason at all.
I'm not going to lie. The other thing, Ms. Romo, did you look at that step-down instruction?
Yes, I did.
And did you send it to Ms. Morrissey?
I didn't get anything sent from Ms. Roma that I'm aware of.
We did.
When? What are you talking about? Oh, yes, of
Did we
course.
not
I
send
had
it?
their jury instructions from 2 weeks ago. I thought you were talking about
Are you
something
comfortable
recent.
with that step-down instruction? It sort of follows.
Well, let's go through it.
I followed,
I'll let you guys go through it, and
I
then give me
followed
the
the
instruction.
EGI.
Yes.
Exactly, Judge.
I read the step-down instruction this morning, and I don't have any concerns about it.
Okay, the one we're saying. Well, I'm gonna put down the I'm gonna get the instructions together. I'm gonna give you, I'm gonna number and get you copies, and then I wanna go over them on the record, and then we will
Coffee Mom.
read them to the jury and go to closing argument. All right.
All rise.
Okay, so Judge is going to go get his robe on. We're going to get to work here. That was off there. Oh, did you see her tear the paper? Did you see her tear the paper? Oh, that's awesome. She's still tearing it up. She is so mad. I think they're going to meet out in the parking lot after this. Oh, wow. Oh, my goodness. This is good stuff. This is good stuff. Oh, let's see. That one right there. Okay. Why does this sound amateurish? Because it is, at least on one side. The prosecution is out of their league. They're in deep, deep water and not able to swim. Yes, epic for sure. It is wild. It is wild, 7, 100%. Cameras in the parking lot, says Golden Law. Yeah, it sounds like they want to go to each other's throats. So what you had there is the state presenting basically the chance for rebuttal witnesses, saying, hey, there was stuff that was brought up that we didn't get a chance to address. And the judge basically said, no, I'm not going to allow it. We're just going to go straight to reading the instructions to the jury. She pulled a Darrell Brooks on that paper for sure. Nancy Pelosi, we've got all the all the names in there. She should make a box for it about now. Start building, really. The gloves are coming off. This is bizarre. I hope you guys like it. I did change the timeout on the slow mode to 15 seconds. I think that's better for those of us that are trying to follow a conversation. It makes it easier. Hopefully people won't be spamming stuff. Mods can take care of that if there's a problem that way. But yeah, let me just say, let's try to make some ground rules here in our chat. I know that some of us have strong opinions on different subjects that we do breach a couple times. If you find somebody who has the opposite strong opinion, and you realize that you're not going to convince each other, let's agree to disagree. I'd rather have both of you here, and then at the right time when we have opinion questions that you guys can each share, than somebody get all upset and leave chat and decide that this isn't the place for them because they're always being attacked or something. So this is not calling out anybody. Everybody who's been here has been awesome. I just want to sort of get ahead of the curve on that front. Yeah, we're trying not to get political in here. There's plenty of places you can go and discuss politics. Twitter being one of them. Let's see. So jury instructions shouldn't be so bad here. It's one charge instead of 76. Yeah, it'll go much quicker. Though he's going to read both the charge for second degree murder as well as the lesser included of manslaughter. So it's just a little bit. He's going to read the self-defense and everything. So everyone pinky swear. We're all going to be good. Judge is finding his robe. He's printed out the papers for the jury, and we're going to get going here. Yes, we do have people from all over the world here. It is amazing how many people connect from every time zone, just all over the place. Let's see. I would hire a defense if I need a lawyer. I'd run across the highway to avoid these state's attorneys. Churchy says, cover it. How to pin a comment. Go to chat window during live stream or Premiere. Find a message from live chat, even your own. Click pin. What should I pin? I haven't come across anything that I've said that's so profound that deserves to be in front of everybody for the entire stream. Maybe our hotline number, our phone number, which it looks like we got a message already. Let's see. Let's see who calls. Oh, it's Shane from Ireland. Should we listen to Shane? Let's do a quick vote. Is Shane in the chat? Shane, I didn't see a join. He might not have got a notification. Lots of people are saying they're not getting notifications when we go live, and apparently that's going to be. Let's see, whose turn is it to take care of that? It's Fairy66. She won the internet here this time around. So if you can take care of that notification issue for everybody, we'd appreciate it. Let's see. So yes, let's listen to Shane. He's not here, but we're going to play it anyway. And hopefully, I mean, it can't be much worse than what we heard from the lawyers already, right? So I'm pretty safe playing Shane's message here.
Hey, Scott. It's Shane here from Ireland. I missed your talk this morning, just the way my life is at the moment. So I'm watching a replay of it. Great chat, great interaction. I'm going to try and join the stream later on tonight. I don't know if I'll be able to do it later on in the week, or maybe from now on, as often as I have up to now, which is a real pity because I got to love that channel and loved everybody in chat. So I'll do my best, but it won't be as frequent as before, which, as I say, is a pity because, you know, it's just great meeting everyone, just chatting to everybody. But whatever you do, make sure Abby stays away from that red button, okay? Anyway, talk to you later. Bye.
Awesome. A sad note, Shane won't be able to join us quite as often. And it's difficult when you're in the UK and we're in the US and the time differences and everything else. But we do love Shane. Appreciate the feedback. He's been here quite a bit. And I think right now he's on one of the replays, so he might not know that we're live. He might join us later. Anyway, Judge is still looking for the robe or maybe iron out the wrinkles or something. The state has nothing. The state has nothing in this defense or in this prosecution. Oh, I don't know what their closing statements will be. I mean, normally you're going to go through and reiterate all the points you made, but really all they have is, hey, we have this other theory that might also have worked in this, considering the evidence. But there's no point. There's no proof that that one thing that clinches it for them. I haven't seen any of that. Yes, Ferry, you typed first. If you don't want the internet, don't be first in chat. But unfortunately, you want it, you own it. So even if it's broken. Shane is a nice bloke. We love him. He'll be here in spirit, says Ann. Shane's accent is great as well. Let's see. Patty says, I'm not getting notifications. Yeah, I don't know how to fix that. I've got a couple messages as well from people who said, even just right before I came live saying I didn't get notifications. And it's a YouTube thing. YouTube is like, it's part of the algorithm. They suggest notifications randomly, and sometimes you get them late, 10 minutes into it, suddenly you get a notification that, hey, it's been live for 10 minutes. But I don't know how to fix that. I might have to employ like an external program like Discord or something. Let's see. Sean says, I got to remember it. I couldn't handle the pressure. Yep. Poor Ferry, says Donna. Yeah, it's a big job. The internet's a big thing to keep running, and the notifications and everything. That's all part of it. YouTube notifications show up like divas when they want to. They're like cats, really. You don't ever own a cat. The cat graces you with its presence when it feels like it wants something. Can the prosecutor talk for an hour? I hope not. What would she talk about? Literally, would she talk about all the witnesses that testified that the defense story holds up against the evidence? Crazy. The way it sounded, judge denied the request, so it should be instructions and the jury deliberations. Right, Last Poet? I think that's what we've got. He's just printing out the papers that he's going to read to the jury with the statement that both sides agreed on the self-defense statement. Ferry says, I'm going to cancel my notifications if it brings this much responsibility. Yeah, yours clearly worked. So whatever you're doing, it's working. So just teach everyone else how to do that, Ferry. 2 cents says, not convinced of defendant's innocent. If so, he might get away with murder. State's fault. He may. 2 cents. I'm not saying this was self-defense. I'm just saying that the evidence the state has presented has not proved that it was murder. And that's the standard they need to meet. And if they can't prove it was murder, that's their burden to bear. He doesn't have to prove that it was self-defense. Paula says, I get notification. I hit the bell to be notified at all times. Internet ownership is a big job. This comes from someone who did a phenomenal job on a previous day. TW, thank you for that. The prosecution is just not prepared. This should never went to trial to begin with. What blows me away is that he's been in jail for 2 years waiting for this. It's bad. I wonder if the prosecutor will point the gun at the jury. Yeah. Bella says guilty for me. She's convinced. That was enough. Colette agrees with 2 cents as well. What was 2 cents? Which one were you? I'm not convinced that the defendant's innocent. Okay, got it. Katrina, who would he sue? We talked yesterday to Matthew. Was it Matthew talking about sovereign immunity, where the government is immune from lawsuits in this sort of situation? I don't think he has anyone he can sue. I mean, he might try to sue the guy whose property he was trying to buy, or sue his estate, but I don't know. I don't know. Does he want the property still? I think he could still have the opportunity to buy it if the family will sell it to him. The state talks a good game, but the evidence just doesn't prove it. It's very well maybe unlawful, but where's the evidence that makes me confident about it? Right. It's possible he might be getting away with murder. He might have thought this through. That's the one thing he said that I didn't like how he said it. Dean, when he was on the stand, I think it was under his direct examination, he said that he's thought about this every day for 2 years. Like he's replayed this in his head every day for 2 years. Almost, it's like, okay, so that's why it's perfect. But maybe he was just prepared. As it's National Ferry Owns the Internet Day, I decree free pickles for all. Thank you, Ferry. I will go and collect mine. Just where do I print the coupon? Or coupon? Which one's right for you? Is it coupon or coupon? This trial is terrible right from the beginning. It's comical in many ways. If I came in first, how much could I sell the internet for? Well, one of the rules about selling the internet is you have to do it on the internet. And so I think it's only appropriate that the page where that listing would be made is probably Reddit, since that is the front page of the internet. But value, it's very subjective. Maybe I'd feel more sure about guilt if the investigation wasn't a house of cards. Not a good start. Expect a fairly fast not guilty. Hi from Glasgow. Welcome, Carly. Glad to have you here. Patty's Home says, I found Dean Cummings very credible. The state has not proved their case, in my opinion. Sue for false imprisonment. I think they had the charges. They met the level that they needed to make the arrest. The judge ordered no bail based on the evidence they had, or at least they said they had. But I think he doesn't have anything to. I don't think he can sue. Sadly. The only answer I have is why bring this case if they had a personal issue with Cummings and are looking forward for anything to put him away. I'm curious with all these the previous situations with the neighbors. There was almost some testimony. It sounded like it was going the route where the neighbors were frustrated that the police weren't doing anything about it. And the one guy said, I figured I would be doing him a favor to call the police on this, to get the police to do something about this. I'm not sure if that was insinuating that the police tended to side with the mace man or what. But if that's the case, maybe that might be some of the frustration they were talking about. Ann says, I vote not guilty, not proven. Right. Charlie Peterson says, to be clear, you don't get proven innocent. Even if there's even a tiny reasonable doubt, he should walk. Right. Beyond reasonable doubt is a level they have to reach to convict. Just saw some movement on the screen, but the judge still is not there. Hopefully we will find his robe. real estate deals are so complicated now. Wear Kevlar. Yeah, that was bizarre. What's with the realtor saying, I can't let a lawyer or another realtor look at this contract or I could lose my license? I've never heard that before. But also, if it's that big of a land deal, why didn't he bring somebody representing him when he was clearly going to meet someone representing the other party? 2 Cents says, recovery addict. I've seen where innocent people get compensation from suing state, the police, etc., but it doesn't always work. Right. I'd love to see it happen, but I just don't know if there's a mechanism in place for him. Yeah, the Mr. Torso, for sure. The decedent, the deceased. What a character. Can you imagine going to get in the mail, with your mailboxes right next to his every morning? Do you like put on a face guard and a gas mask just because you know you're going to get sprayed? It's like dealing with a skunk, It's just anytime you're around, they spray. Hi there. Good morning, AJ. Welcome. Glad you're here. Appreciate you coming back. Alexis is taunting us. She's having some fried pickles for lunch. Do share. Thanks for the tips, TW. Might just be a couple minutes here as we wait for that. 2 years locked up for this nightmare. Yeah. So if this goes as fast as we think it's going to go today, with only just a handful of papers as opposed to the volumes that the Brooks trial had for the jury, it's going to be pretty quick. And then we're probably going to move on tomorrow to the Matthew Terry case. Down in Florida, the math murder, the fleeing girlfriend, strange bloody suspect in his underwear in the woods. It's going to be bizarre. We might need some background music while we wait. There's not a lot of things going on. Should we pull up a different trial and watch that for a minute? That might be a little confusing. Let's see. What sort of music are we going to go with this time? How about this one? There we go. It's just the silence scares me for some reason. It's like I'm doing something wrong. If everything's quiet, I'm constantly checking to make sure I didn't miss something. Okay. There we go. There's more evidence against the deceased than there is against the defendant. 100%. Sean, are you making dinner already? What is it, and when could we come over? I think his neighbors became immune to mace due to living next to a serial macer. What will the jury do with Cummings? I think he's going home, not to prison. I believe you're right. I think in Arizona, this part of Arizona, I think self-defense is going to be on their mind when they're in there. You're talking about the Matthew Terry case in Florida. Yeah, that's interesting. I've started to catch up on that one. I'm going to have to do some homework today to get all the facts. I'm going to have to watch all the old footage at like 2 times speed to try to catch all that and get up to speed on that. 2 Cents says, please don't put any liquids near your computer, buddy. Okay, so this cup right here, whoa, it's actually empty. It's empty. I didn't trust myself with my True Crime Addict mug next to the computer. So I have my water. Way over here with the lid on. I'll drink from that carefully away from my computer. Alexa says, I still want to push those colorful buttons. They are so much fun. Each one of these on this button is a song. So I've got red, orange, yellow, green, sort of like an aqua, blue, purple, and white. So if you want to choose a song, tell me what color and I'll push it for you. That's the next best thing, Alexis. We're on green right now, by the way. Fish and chips. Oh, man. Fish, chips, and vinegar. Put water bottle into mug. Oh, like, so it would be like a water bottle holder? Like that. Teal, aqua. We can do that. We'll switch the songs here. 3, 2, 1. I went with the first one I saw. Sorry there, Jenna. Purple's a good one as well. I really like that one. We're on green already, Jenna. So Katrina says it's breakfast time here. I could go for that. Can't wait for the state's closing. Yeah, what are they going to say? What testimony are they going to remind the jury of? Bring back to your remembrance. This is what you heard. This is the truth we want you to understand. I didn't hear the testimony. I heard a lot of, it could have happened that way, but it also could have happened the way Dean said. AJ says, my dad always pretended to trip and spill his plate of food when he was walking. What a stinker. Now I have to do it too. We're cheesy. That's funny. I love fish and chips. Malt vinegar. Not the weak American malt vinegar. In England, they've got the strong stuff. It'll dissolve your tongue if you have too much of it. It is good vinegar. Not cooking yet. Okay, so let us know, Shauna, because we want to be over when it's hot. Lori has voted, and she's wearing the I voted sticker. I would be wearing my sticker, but my youngest son, who was with me when I went and voted, appropriated the sticker as soon as it was offered. So he's wearing the I voted sticker today. Donna says, I don't have to fake trip. I actually do trip. Happens. Dad jokes are the best. Welcome back, Lori. Appreciate you being here. Spaghetti for dinner. Baked spaghetti. If we start talking about food too much, we're going to have to call another break, and it's going to be a long one. Ate lunch early, so popcorn for closings. I put the sticker on my dog's forehead. He's not amused, but he voted. Alexis says, I trip and fall at least once a day. I am sorry. That is no fun. Good choice on the music. Teal was a good choice. I like that one. I'm clumsy. It comes naturally. It's a gift. Bite me. What a name. Good morning, friends. Welcome. You're getting the munchies with all the food talk. It happens. My sticker is proudly worn. That's cool. That's cool. Anyway, so for those of you that woke up under a rock or something and haven't been connected to the outside world, today for most of the U.S. is voting day. So please go vote. Let your voice be heard in your community, especially at the local level where your vote can make a big difference. But educate yourself on all the races and vote for the best candidates. Let's see. Mama didn't put Grace near my name. Jenna, Dean has been in custody for 2 years. He does not seem bitter about it. Maybe in the closing arguments, the defense might talk about that a little bit. Bite Me says, I identify and count dead mosquitoes. That's my job. Are you looking for, that would explain the logo. Are you looking for like West Nile virus or what do you do? And where, Bite Me, what region of the globe are you from? Having hummus with raw veg. Yum. 2 cents voted by mail. Patty voted as well. Voting is fun. Do it for the laugh. We'll do it for the right to complain, if nothing else. I trip and fall over hair on the floor. Let's see. Donna says, you can't vote in your country. And she says, I'm Canadian. Oops. Sorry, you guys are typing so fast. I keep clicking on the wrong things. But still waiting for the courtroom. We're going to bring that back here on screen so you can see it. But first I have to do that. Okay. There we go. This way we're not going to miss anything. I can focus on chat and not have to sit cross-eyed looking at the screens. So let's see. Louisiana, yes. So West Nile virus. Yeah, that's nasty. That's a nasty little virus. The mosquitoes carry it. It seems to be spreading slowly as it seems to go further and further every year. Slow mode has its advantages, yeah, but at the same time, I like that you guys are able to talk and get out what you want to say. If you can't get out to vote, at least like the stream, yeah, vote on the important ballot, and it's that thumbs up and thumbs down one. I hope you vote the thumbs up one. I've checked gravity 4 times today alone, Laura. Somebody has to do it. Keep it in check. Make sure it's still working. We should start giving away gravity as well instead of the internet. This judge wants to wrap this up today. He's pushing towards a close. Oh, this is one of my favorites, Charlie. Tomato soup and grilled cheese, lunchtime in chilly New York. Oh, man, beautiful. I'm just checking to make sure I didn't miss any messages. Shane was the last one. All right. I can see some movement there on the camera. I wish the cameraman would do the open mic for us and let us see exactly what's going on. You know, it's petty, but me being a cameraman, having been professionally trained, I'm so frustrated with what's called the white balance on this image. You look at the American flag, and it looks like the white stripes are sort of like tinted blue. There's a feature on these professional cameras where you can point them at a white object and basically set on the camera the information, say what you're looking at is white, so adjust everything accordingly. And it takes about 3 seconds to do. And it's called white balancing. And this one clearly has not been white balanced, so everything has this blue tint to it. And it sets my teeth on edge. The jury is out. The jury's out. The jury has not been brought in yet. They haven't been charged yet, Crafty Cow. So we've got a little bit. Mac, I don't know where Abby is. This is the first time I haven't had her in chat, I think in ever. She's always been here, so maybe something came up. What time is, let's see. What time is it in London?
In London, England, it's 5:08 p.m.
Okay, so maybe tea, supper, something's going on over there. Homemade beef barley soup. I don't like it homemade, but I'm a big fan of the Campbell's version. Mostly because it's perfect with Zesta crackers. That's one of my favorite foods. Right up there with pickles. I mean, it's really close. I can't eat it every day like I could with a pickle, but yeah. New Mexico does have a bright flag. It's a very sunny state. Patty J says, me too, I'm a photographer, and those things bug me as well. Right, and I have a hard time with the focus as well. It seems like he has the autofocus turned on. And autofocus, I honestly, I have it turned on my camera as well, but when I hold up my mug, if I want you to be able to read it, it has to be able to focus on the camera or focus on the mug like that. And because the camera's out of reach, I can't do that. But then I want it to come back and focus on me after the fact. So, but if I was standing there using a professional camera in a setting like this, I would manually be operating the focus to keep it as crisp as possible. Because if somebody just walked in front of you on accident, you don't want the whole focus to be thrown off and then everything blurry as soon as they're out of the picture, which we've seen several times on this one. Chili and fry bread. You guys have some good dinner ideas. Bring enough for the whole class, please. In high school, I had a teacher who did not care at all if you brought, a whole cake to class with you, as long as there was enough to share. So I called Abby's name out the front door, and she must not be in the country. Well, Ashley, I appreciate you doing that. Obviously, England's small enough that you should be able to yell from border to border. It looks small on the map, right? No, that's funny. Keep a lookout for her. She might turn up. Two Cents says, Abby said she's a coffee drinker. Yeah, she's been giving out tea and hugs, and we don't have that yet, this chat, so someone might have to take over for her. Stephen Pearson says, just found this channel. Hello from Scotland. Hey, Stephen, what we do is we sit around and we talk about what we're having for dinner. So just disregard the name of the live stream and the fact that there's a courtroom picture in the background. It's mostly just a food chat where people just says what they want to eat and what they're going to have for dinner. So that's what it's turned into for some reason. And I'm hungry still, so that's probably why. It's my fault. White chicken chili. Oh, love it, love it, love it. So Stephen, yeah, please stay for the food chat, but we also talk about true crime. We're actually right now, we're waiting for the judge to come back into the courtroom. We're looking at the courtroom in New Mexico right now where Dean Cummings is on trial for murder. He's charged with murdering a man that he was in a deal with or negotiations with to buy his property there in New Mexico, sort of remote desert area. And things went south, and it ended up with him shooting the man and killing him in his own house with a assault-style rifle, a sporting rifle. And so now he's on trial. He's been in jail for 2 years waiting this. waiting for this day, his day in court. So we have a jury that has been listening to all the evidence, and later today we anticipate that after the prosecution and the defense make their closing arguments, that jury will be charged with determining if he's guilty or not. So right now we're waiting for the judge. The judge is preparing the documents that he's going to give to the jury or read to the jury as to how they should do their job and go about determining a verdict. And so we're just waiting for that. We hope he'll be back here in just a minute. And in the meantime, we're talking about food. So, hey, Abby, I didn't see you sneak in there. No problem. You're welcome anytime. We were talking about you though. We were definitely missing your presence, Abby. Glad you can be here. So yes, all the food emojis are appropriate in chat. See how many you can fit in a single message. I think that's the contest right now. Did the judge set a time limit for each side's closing arguments? No, but I don't think they're going to be very long, mostly because prosecution A doesn't have anything to argue, and B, the defense doesn't have to prove that it was self-defense, even though they have. So that's where we're at. Yes, this is the food court. Charlie, that's a very accurate description. Oh, Ola, we're going to give you credit. It looks like you were the originator of that idea. So Charlie was just quoting you. Oh, Jamaican jerk shrimp and short scotch, straight up. Okay, I can't do this scotch. I'm not a drinker, Bella, but anything shrimp catches my attention. I will say the best shrimp I've ever had. I was on the dock I think I was in Oslo, Norway, and the boat had just come in, had caught shrimp. They had brought them in and steamed them right there. And we got to eat fresh leftover shrimp that were like too much. There was like 10 pounds of leftover shrimp. And I glutted myself on them and then threw them to the seagulls. It was amazing.
Counsel,
It was
I
beautiful.
handed out a set of jury instructions. Does the state have any objection to either content or the order of the jury instructions?
No, Your Honor.
Defense team, question.
No, Your Honor.
Approach the bench for a second.
See, the judge has blue hair because of that white balance. Everyone sort of has that blue tint. It looks like we're looking through blue sunglasses. But. One down on the water bottles today. I've got another one here ready to go, though. Not sure why we went back up to the flag. Thanks for that, Abby. On the screen right now is our Recovery Addict hotline. This is my burner phone where you can call 24 hours a day, 7 days a week. Leave a message, send a text. Send me a picture of you with your mug. A mug shot with your mug. Whatever you think would be appropriate to share on the air. And if your opinion is appropriate and mine match up, there's a good chance it'll be live on the show.
Well, you may be seated. Okay, ladies and gentlemen of the jury, what we're going to do is I'm going to read you closing instructions, and the lawyers will give you the closing statement. But I need to ask, how many of you still need to go vote? All right, so I can plan accordingly to this afternoon, okay? Because you certainly will be allowed. We'll go early if we have to. If you haven't reached a verdict, we'll do what we need to do so you folks can go vote. All right.
Hurry and reach your verdict,
All right.
so you can go vote.
And Lieutenant Tomlinson is zip tying the rifle.
Again, because the zip tie was broken when the defendant
I'll let him get
showed
done
how
and I'll
to.
read you the instructions. Take your time, Lieutenant.
When the defendant was showing how he cocked the rifle during the struggle, he broke the zip tie that held the chamber open. So they're zip tying it again. It's possible that the jury might ask to see the rifle during their deliberations, so they want to obviously lock it in a safe position. Yeah, I wonder if there's a story behind who made that for him. It looks like a nice name tag there. Way to go, Roxanne. Wear that voted sticker with pride. So, and those zip ties, the reason why it can break is because it barely holds the chamber open a little bit. It just keeps it from locking closed, and the edges of that action as it closes, it's sharp metal on metal, and so it's almost like scissors. So it's in that situation, it's pretty easy to I forget what the terminology is. That part of the gun that slides the chamber as that closes, it really does cut that pretty easily. And it didn't seem to slow down Dean at all while he was demonstrating how he cocked the gun in his fight. Patty, I think they'll be just long enough for everyone to introduce themselves, pick a foreman, and say, well, that was easy.
I'm going to read you some instructions, but you will get a copy of them. Okay. You have heard all the evidence. It is now my duty to tell you the law that you must follow in this case. The law governing this case is contained in instructions that I am about to give you. It is your duty to follow the laws contained in these instructions. You must consider these instructions as a whole. You must not pick out one instruction or parts of an instruction and disregard others. A copy of these instructions will be given to you when you begin your deliberations. The law presumes the defendant to be innocent unless and until you're satisfied beyond a reasonable doubt of his guilt. The burden is always on the state to prove guilt beyond a reasonable doubt. It is not required that the state prove guilt beyond all possible doubt. The test is one of reasonable doubt. A reasonable doubt is doubt based upon reason and common sense, the kind of doubt that will make a reasonable person hesitate to act in the graver and more important affairs of life. You are the sole judges of the facts in this case. It is your duty to determine the facts from the evidence produced here in court. Your verdict should not be based on speculation, guess, or conjecture. Neither sympathy nor prejudice should influence your verdict. You are to apply the law as stated in these instructions to the facts as you find them, and in this way decide the case. You alone are the judges of the credibility of the witnesses and the weight to be given to the testimony of each of them. In determining the credit to be given any witness, you should take into account the witness's truthfulness or untruthfulness, ability and opportunity to observe, memory, manner while testifying, any interest, bias, or prejudice the witness may have, and the reasonableness of the witness's testimony considered in light of all the evidence in the case. You should consider each opinion received in evidence in this case and give it such weight as you think it deserves. If you should conclude that the reasons given in support of the opinion are not sound, or that for any other reason the opinion is incorrect or not correct, you may disregard the opinion entirely. An expert witness is a witness who, by knowledge, skill, experience, training, or education, has become an expert in any subject. An expert witness may be permitted to state an opinion as to that subject. You should consider each expert opinion and the reasons stated for the opinion, giving them such weight as you think they deserve. You may reject an opinion entirely if you conclude it is unsound. In this case, as to the charge of murder in the second degree contained in count 1, there are 4 possible verdicts as to the defendant, Dean Cummings. 1, guilty of second degree murder. 2, not guilty of second degree murder. 3, guilty of voluntary manslaughter. 4, not guilty of voluntary manslaughter. You must consider each of these crimes. You should be sure that you fully understand the elements of each crime before you deliberate further. You have the discretion to choose the manner and order in which you deliberate on this count, but you must return a unanimous verdict of not guilty on second degree murder before entering a verdict on voluntary manslaughter. You will first decide whether the defendant is guilty of the crime of second degree murder. If you unanimously find the defendant guilty of second degree murder, then that is the only form of verdict which is to be signed as to this count. If you unanimously find defendant not guilty of second degree murder, then you should sign the the not guilty form as to second degree murder. If after reasonable deliberation you do not reach a unanimous verdict on second degree murder, you should not sign a verdict form for that crime, and you should not proceed to reach a verdict on the remaining crime of voluntary manslaughter. If you unanimously find a verdict of not guilty on second degree murder, you will then go on to the consideration of the crime of voluntary manslaughter. If you unanimously find the defendant guilty of voluntary manslaughter, then that is the only formal verdict that should be signed. But if you unanimously find the defendant not guilty of the crime of voluntary manslaughter, then you should only sign the not guilty form. If after reasonable deliberation you do not reach a unanimous verdict on voluntary manslaughter, you should not sign a verdict form for that crime. You may not find the defendant guilty of more than one of the foregoing crimes. If you have a reasonable doubt as to whether the defendant has committed any one of the crimes, you must determine the defendant is not guilty of that crime. If you find the defendant not guilty of all of these crimes in count 1, you must return a verdict of not guilty as to this count. For you to find the defendant guilty of second degree murder charged in count 1, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant killed Guillermo Arriola. The defendant knew that his acts created a strong probability of death or great bodily harm to Guillermo Arriola. The defendant did not act as a result of sufficient provocation. The defendant did not act in self-defense. This happened in New Mexico on or about the 29th day of February of the year 2020. For you to find the defendant guilty of voluntary manslaughter as charged in count 1, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. The defendant killed Guillermo Arriola. The defendant knew that his acts created a strong probability of death or great bodily harm to Guillermo Arriola. The defendant acted as a result of sufficient provocation. The defendant did not act in self-defense. This happened in New Mexico on about the 29th day of February 2020. The difference between second-degree murder and voluntary manslaughter is sufficient provocation. In second-degree murder, the defendant kills without having been sufficiently provoked, that is, without sufficient provocation. In the case of voluntary manslaughter, the defendant kills after being sufficiently provoked, that is, as a result of sufficient provocation. Sufficient provocation reduces second-degree murder to voluntary manslaughter. In addition to the other elements of second-degree murder or voluntary manslaughter, the state must prove to your satisfaction beyond a reasonable doubt that the defendant acted intentionally when he committed the crime. A person acts intentionally when he purposely does an act that the law declares to be a crime. Whether the defendant acted intentionally may be inferred from all of the surrounding circumstances, such as the manner in which he acts, the means used, his conduct, and any statements made by him. Sufficient provocation can be any action, conduct, or circumstance which arouse anger, sudden resentment, terror, or extreme emotions. The provocation must be such as would affect the ability to reason or to cause a temporary loss of self-control in an ordinary person of average disposition. The provocation is not sufficient for an ordinary person would have. The provocation is not sufficient if an ordinary person would have cooled off before acting. Great bodily harm means an injury to a person which creates a high probability of death or results in serious disfigurement, or results in the loss of any member or organ of the body, or results in permanent or prolonged impairment of the use of any member or organ of the body.
Okay.
An issue you must consider in this case is whether the defendant killed Guillermo Arriola in self-defense. The killing is in self-defense if, 1, there was an apparent or immediate danger of death or great bodily harm to the defendant as a result of Guillermo Arriola attacking Dean Cummings. 2, the defendant was in fact put in fear by the apparent danger of immediate death or great bodily harm and killed Guillermo Arriola because of that fear. And 3, a reasonable person in the same circumstances as the defendant would have acted as the defendant did. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. If If you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. A person who is defending against an attack, defending another from an attack, or defending property need not retreat. In the exercise of the right of self-defense, a person may stand the person's ground and defend himself. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agrees. Your verdict must be unanimous. It is your duty to consult one another and try to reach an agreement. However, you are not required to give up your individual judgment. Each of you must decide the case for yourself, but you must do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own view and change your opinion if you are convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the purpose of reaching a verdict. You are the judges of the facts. Your sole interest is to ascertain the truth from the evidence in this case. You must not concern yourself with the consequences of your verdict. Now the lawyers will argue the case. What is said in argument is not evidence. It is the opportunity for the lawyers to discuss the evidence and the law as I have instructed you. The state has the right to argue first. The defense may then argue. The state may then reply. State, you may.
Okay. So those are the instructions. This is the closing arguments. So we have the state first and then defense, and then we're going to charge the jury and have deliberations. Like, first, I'd like to apologize on behalf of New Mexico for this circus.
Thank you for your time and attention, ladies and gentlemen. It's been a long 7 days, I think, that we've been able to all be in this courtroom together. So I thank you for your time and attention in this case.
She's going to walk away from the mic.
On February 29th of 2020, the defendant, Mr. Cummings, shot and killed Guillermo Adiola at his ranch in Sandoval County. As I said at the beginning in opening statements, we know who did this, and we know how he did it. And so you are the finders of fact. It's your job to determine whether or not this crime was committed with sufficient provocation, making it a voluntary manslaughter, or without sufficient provocation, making it a second-degree murder.
I'm going to try to turn up the sound, but it'll have some background noise.
Homicide and self-defense. This is your job to determine this. The state has presented all of its evidence, and the defendant has presented his evidence. We know that Mr. Cummings shot Mr. Adiola with this AR-15-like rifle,
AR-15-like,
with a 30-round magazine by shooting him twice, once in the head and once in the chest. What weapon was used is not an issue, ladies and gentlemen. What magazine was used is not an issue, ladies and gentlemen. We know this. This is fact that we know. Why this is done, this is what you're asked to determine. And the state has presented evidence to you that Mr. Adiola was not armed. The force that was used was not reasonable. As I said in the beginning of this case is about reasonableness. And you, ladies and gentlemen, determine what is reasonable here. As I said, the judges gave you instructions on what the law is. Second-degree murder is not an act as a result of sufficient provocation. Voluntary manslaughter is when someone does act as a result of sufficient provocation. So the only difference is that number 3 for you to decide. So what is sufficient provocation? You're going to have the instructions that the judge read to you. You'll have those to look at, to read, to think about. Would an ordinary person of an average disposition have done the same as Mr. Cummings did? It's not sufficient if someone would have cooled off before acting. Would an average person have walked out of the trailer, cooled off? If Mr. Adiola was acting crazy and aggressive, was that sufficient provocation? Would Mr. Aliola have walked off? As I said, this is a case about reasonableness, and you determine what was reasonable on that day. So let's talk about the evidence in this case. Mr. Cummings was going to purchase this ranch out in Sandoval County from Mr. Adiola. Ms. Landers drew up that real estate contract. She's known Mr. Adiola for about 20 years. He was going to buy it for $149,000, and Mr. Adiola let him park his fifth wheel trailer out there for $300 a month. Ms. Landers told you she thought that Mr. Cummings was taking advantage of him, that this wasn't a fair deal. She said that Mr. Adiola liked Mr. Cummings, and they got along well when she saw them together. She thought that Mr. Cummings also liked Mr. Adiola as well. They were friends. Mr. Adiola had even given Mr. Cummings a horse. She said that she thought Mr. Cummings was kind of strange and something was off about him. They did not yet have an executed contract to purchase that land. Mr. Cummings told you, when he took the witness stand, that he also thought he got along good with Mr. Adiola. They had a lot in common. They hung out, they drank whiskey, they went horseback riding together. They got along just fine. Mr. Cummings testified that Mr. Adiola told him about an incident with a hammer. He said that Mr. Adiola had told him that he had scared a guy by hitting a car with a hammer. And he thought, hearing that story made him think, well, I better be careful. And this is a man who took the stand and told you about his vertical gains, and he made a living as a world-class skier. He told you he took multiple helicopter runs up an amazing big mountain, and that this dangerous career of his required technique and athleticism. But he thought I should be careful because an old man told me a story that happened years ago about a hammer. Is that reasonable?
Yes.
Mr. Cummings testified that he arrived at Mr. Adiola's trailer at about 10 or 11 p.m. the night before. He said that he was watching a movie and he dozed off. He thought that he smelled propane, and so he went to his fifth wheel trailer. Mr. Adiola arrives at the ranch the next day, February 29th, 2020, Leap Day. Mr. Cummings said that he believes Mr. Adiola arrived at 1:32 p.m., broad daylight. Remember, this area is so remote. Mr. Cummings could see him coming from a distance. This area is so remote, he would have heard a large truck approaching this ranch in the middle of nowhere. He had time to prepare his attack. Mr. Cummings testified about what happened that day. He told you, ladies and gentlemen, that he was in the kitchen and Mr. Adiola was unloading groceries with a scowl on his face. They talked for 8 to 10 minutes, is what he told you. And that because he called Mr. Adiola a scammer, that made Mr. Adiola so mad that he attacked him out of nowhere, just for being called a scammer. Mind you, Ms. Landers believed that the contract was in Mr. Cummings' benefit. He was going to live there for $300 a month, had full access to that land, was given a horse for $300 a month.
Dean didn't like the contract.
Mr. Cummings told you that he was slammed into the counter and fell to the ground. And he grabbed his rifle from the wall and crab walked down the hallway while Mr. Adiola is swinging at him, not hitting him, but swinging at him. At the beginning of this trial, ladies and gentlemen, I told you that Mr. Adiola can't tell us what happened that day. The evidence will show what happened that day. And is it reasonable to believe that Mr. Adiola, because he was called a scammer, would attack Mr. Cummings, this professional athlete? This is a case of reasonableness. Or is it more reasonable to believe that Mr. Cummings made up this story to cover what he did? You're the judges of the credibility of the witnesses. You saw every witness take that stand. You saw all of the evidence admitted. You determine who to believe. You determine what's true on that witness stand. You heard a story of Mr. Cummings and how what he told you contradicted every witness that took that stand. It contradicted what Mr. McCullough said happened, what Ms. Lander said would happen, what the responding deputy said would happen, what's recorded on the belt tape of the responding deputies, what the 911 calls say. He disagrees. Even his own expert. His testimony even contradicted his own expert. We know Mr. Cummings shot and killed Mr. Adiola. He doesn't immediately run out and go get help. He doesn't think, hey, I need to call an ambulance. No. He said, I got to go wash my face and hands. And I got to go back and I got to get soap. And I got to go back out and wash my hands. He changes his clothing. He walks around the ranch. He even said that he's medically trained. And he walked over, peeked in the window, and saw that Mr. Adiola wasn't breathing. His chest wasn't moving is what he told you guys. But he was lying face down. Mr. Cummings told you, ladies and gentlemen, that at about 3:30 p.m., he is the time he believes he was washing his hands off, his face, changing clothes. So if Mr. Adiola arrived at the ranch at 1:30, what did he do between 1:30 and 3:30? That's 2 hours of unaccounted time for. Mr. McCullough called 911 at 5:30. What happened between 3:30 and 5:30? That's 4 hours of unaccounted time for. Let's talk about Mr. McCullough. Mr. McCullough testified that he was out riding his dirt bike out at Cabazon Peak. He said that he was driving at a Y intersection. He went to the right until the road ended. And he saw a male walking around outside by some structures. He said he couldn't quite look at the male because he was trying to keep his bike on the road, and so he turned around and went back to that Cabazon Peak point of interest sign that he wanted to read. He said that Mr. Cummings came up to him while he was at this sign, and he starts talking to him about motorcycles. I like the motorcycle, telling him how he likes motorcycles. And they have this friendly conversation with a stranger about outdoor sports. He doesn't say, I need help or anything of that nature. Can you call 911? No. He's like, hey, let's talk about motorcycles. That goes to the reasonableness of his actions on that day. Mr. Cummings then drives off, not to get help, not to get cell phone service, which is 4 miles from the ranch. And then he decides, you know what, Mr. McCullough is going to be a good witness for him. So he drives back, talks to Mr. McCullough again, some more. They're chit-chatting. And then when Mr. McCullough goes to leave is when he waves him back over and says, I'm in a little bit of trouble and I need help. When Mr. Cummings took the stand, he denied that he ever left and came back. His story contradicts Mr. McCullough. So you judge the credibility of the witnesses. Mr. McCullough testified that the defendant told him he needs help. Not Mr. Adiola needs help. Mr. Cummings needs help. He tells Mr. McCullough that he was sprayed with a poison. He never said mace. He never said I was in a fight for my life with this gun. He said I was sprayed with a poison. And the poison burned his skin and his face and made it difficult for him to breathe. Mr. McCullough sees no injuries. He said he didn't see anything on Mr. Cummings that night. He never told any witness that he was in a fight, that he was in a battle for his life with that gun. Not law enforcement, not Mr. McCullough, nobody. He said that he was sprayed with poison. That is the one consistent thing he tells all of the witnesses. And that is the one thing he's holding on to. He wants to make sure that everybody is a witness to this can. Everyone needs to see that Mr. Adiola had this in his hand. And I urge you, ladies and gentlemen, to feel this. Hold it.
Spray it.
So Mr. McCullough pulls out his cell phone, calls 911, and you have the 911 calls and evidence, and I urge you to listen to them. You can hear in the fourth audio, Mr. Cummings is talking in the background. You can hear in the audio on the first and second calls, he's talking to a friend. He's not calling the 911 operator. You can hear him in the fourth audio call calling the 911 operator. So in calls 1 and 2, he's chatting with a friend. You can hear him in that call telling this friend that he doesn't feel too good and his whole left side. Something about his whole left side. But he testified that his right side was straight, to you, ladies and gentlemen. Mr. Cummings didn't call law enforcement until 13 minutes after Mr. McCullough did. You heard Mr. Cummings testify that he was 10 feet away from the truck. Mr. McCullough was 10 feet away from the truck. He wasn't asking him any questions about where the gun is and if anyone needs help. But you can hear the calls and you can hear those questions being asked. But that's what Mr. Cummings told you, ladies and gentlemen. He said that he called his dad. And Mr. McCullough described the demeanor of Mr. Cummings on that night as calm, not at all frantic or upset. Is that reasonable? He just shot and killed a man and is hanging out with a stranger talking about motorcycles. Is that reasonable? Mr. Cummings tells Mr. McCullough that he washed his hands, changed his clothes, washed his face, and that the gun is in the back of his truck. And he told you a different story. He said that he immediately put that gun against the porch. So again, his testimony contradicts what Mr. McCullough said. Mr. Cummings asked Mr. McCullough to be his witness that the guy attacked him. And Mr. McCullough told you, ladies and gentlemen, how could I do that? I wasn't a witness to anything like that. I wasn't there. Mr. McCullough follows Mr. Cummings back to the ranch to see if he could render any aid, but Mr. Adiola was past the point of aid. He said he was bluish or grayish.
Like everyone in the courtroom on our feed.
But he wanted to make sure that Mr. McCullough saw what was in Mr. Adiola's right hand. You heard Mr. McCullough say that Mr. Cummings really wanted him to see that black canister because he wanted to make sure that he had a witness that Mr. Adiola had attacked him with the black canister. Mr. Cummings was obsessed with showing everyone that Mr. Adiola had a can of poison. He needed a witness to this poison. And again, he never told anybody there was a struggle. He needed a
We
witness
might have
to this.
some gruesome pictures coming up. So just be aware of that. I can't control
Mr. McCullough
that.
was the first person in that trailer after the homicide. He smelled nothing. No poison, no neurological agent, no mace. Mr. Cummings made this whole thing up to justify what he did. And you can see in that photo that can is facing Mr. Adiola. Mr. McCullough goes to Cabazon Peak to wait to law enforcement, and he said that he took out his ID because he knew that law enforcement would want it. So he was there waiting for law enforcement to lead him back to the ranch. Mr. McCullough's call was at 5:31. Law enforcement is dispatched at 5:40, and Sergeant Crispin testified that they met with the calling party, Mr. McCullough, at 6:26 p.m. Again, more time. Mr. McCullough isn't there, and Mr. Cummings isn't there. He's back at the ranch. There's more time there. Law enforcement goes to the ranch and they encounter Mr. Cummings at his truck at the exit. And he tells law enforcement, as soon as they come upon him, self-defense, self-defense. He says that he was harmed by a neurological agent. And you can listen to Deputy Walker's belt tape. You can hear him say he was harmed by a neurological agent. He told Deputy Walker that it must have been chlorophyll. And Deputy Walker testified that he didn't see any injuries on Mr. Cummings. He had no symptoms that he would expect to see of somebody who has been sprayed by a neurological agent or mace. No red eyes, no red skin, no rash, nothing of that nature. Listen to this belt tape. There's no panic in Mr. Cummings' voice. He's not frantic in any way. He doesn't ever say he's in a fight for his life. They do a protective sweep of the residence, and he said Sergeant Crispin hung out at the car with Mr. Cummings. And Sergeant Crispin testified that he had been asking Mr. Cummings for his name and his date of birth for about 3 hours. And all he would say is Dean, Dean. And you heard they don't have radio dispatch out there. They're not getting the calls from dispatch that Mr. Cummings had called in. They have to drive 4
Saying what
miles
his
down the
name
road
was.
to get radio service, to get cell service. They're not leaving the ranch. They're there to secure the scene. Even on Deputy Walker's belt tape, towards the end, you can hear the defendant tell the deputies, did you see the device in his hand? Did you see the device in his hand? He wants to make sure everyone's a witness to the device. You heard testimony that Deputy Gutierrez and Sergeant Griffin arrive on scene as well at about 7:30 p.m. Mr. Cummings is evaluated by EMS and released. He's not transported for any injuries from the poison or the chlorophyll or the neurological agent. They take photos of him. There's no injuries on his person that are documented in these photos. There's no rash, no redness, no bruising, no scratches from a fight for his life. Nothing indicative of a fight is on his body. His knuckles don't have injuries from being in a fight, a physical altercation. He didn't tell anybody he had any burns on his hands. Even the expert witness couldn't say what was on his hands other than there's black smudge on his hands. Nobody knows what that is. He could have touched anything in the hours he had from the time he killed Mr. Adiola to the time these photos are taken. While he's being photographed by law enforcement, he tells them that, yeah, he washed off with a hose outside after being sprayed with the neurological agent. He says his clothes are in the back of the truck. Sergeant Griffin testified that they were wet when they collected the clothes, and you can see the clothes there in evidence. The t-shirt clearly looks like it was folded up when it was wet. It's got the wrinkled marks on it. Sergeant Griffin said he smelled nothing on the clothes he collected. New Mexico State Police arrived to process the scene. You heard from Agent Carlos Herrera. Agent Bogue did the diagrams of the scene, and Agent Edgar Lemus helped collected evidence and took photographs. Agent Herrera stated that he collected 11 spent casings from that bedroom. Now think about that. 11 spent casings. That means that Mr. Cummings shot that rifle approximately 11 times in that little bedroom.
We've got some Kool-Aid pictures that are going to be shown.
Now we
So
heard
thank you,
testimony
Donna.
about 2 to the body and 1 grazed the clothes and 3 through the door. That's not all 11. Mr. Adiola didn't have a chance. He was unarmed, and you have an AR-like rifle and 11 spent casings. Not 1 shot, 2 shots, 3 shots, 4 shots, 5, 6, 7, 8, 9, 10, 11.
This is higher math, Roxanne. That's why she's explaining it for the jury.
You heard testimony that the majority of the casings were on the side of the room with the wall. So if the shooter was looking towards the door, these casings are expelling from the firearm to the right. And the majority of the casings are along that wall there. So the shooter must have been facing the door if the casings are popping out that way.
Anyone who's shot and seen what a casing does
1
is
casing
not swayed by this argument.
was on the other side of the room. There's even a casing on that plastic tote. So we know the plastic tote was there.
There was no
So,
statement that it wasn't there.
number 3 on the evidence tag, that's the casing on the other side of the room. There was only one. If the rifle expels these spent casings from the right side of the gun from the shooter, then we know that the majority of the shots were shot facing towards the door.
Hey, Ginger,
If
that
the
gun
gun
could be
was upside
fired
down,
very quickly.
like the expert said, it
It's
potentially
not
could
a
have been,
machine gun,
then the
but it could be
casings would have
fired
expelled
multiple
the
times a
opposite
second.
direction. And we have one spent casing on that side. And you heard they can move around, but the majority are on the right, on the other side of Mr. Adiola's body.
That's my understanding, True Celtic, the grass casings.
You saw Mr. Cummings' reenactment of what he believed happened that day. He said that he shot 2 times into the ground. And we heard testimony about the muzzle patterns. But when Mr. Cummings came and did his reenactment for you, ladies and gentlemen, in this small room, when he did it with that little blue gun, he pointed it directly at the ground. He never, in his reenactment, ever said the gun was upside down. That's different than what his expert said. More casings. Let's talk about the rest of the residence. This is the door outside, to go outside, right directly across from the bathroom. You heard Mr. Cummings tell you, ladies and gentlemen, that yes, he went into the bathroom, and that he was able to, at that point, when he was in the bathroom, he was able to pull the lever back. This is not an easy task. And make the rifle ready, chamber it around. This takes affirmative effort to do that. And he's going to tell you, ladies and gentlemen, that after he chambered around, Mr. Adiola continued to still attack him. Is that reasonable? If somebody pulls a rifle, chambers around, are you going to still continue to attack that person, or are you going to go out that door? Are you going to directly turn around right outside that door and go out the porch? What's reasonable, ladies and gentlemen?
It's not bad yet. This is the prosecution's side. We'll see how the defense handles this. I think they're going to tear it apart.
He could have went to the kitchen, gone out the other door, out the other side. What about the rest of the residents? There's no signs of a struggle. The only one who says there's a struggle is Mr. Cummings. None of the evidence shows that. There's no signs of fight. There's the other door. The kitchen has no signs of a fight. Nothing is broken. No broken dishes. If you're a parent, you know not to leave a pot with the handle out. That wasn't disturbed. Nothing on the counter. We see the sunglasses. Supposedly they're Mr. Adiola's sunglasses on the ground. That's the only thing out of place in this room. So what's reasonable? If there was a fight and Mr. Cummings said he was slammed into the counter, nothing is disturbed on the counter. He was slammed into this counter. Those cans are still on the edge. Nothing is disturbed on that counter where he was allegedly slammed into. In the bedroom, there was this big fight in the bedroom. You have clothing on the wall. This is a manufactured home, a mobile home. The walls aren't the strongest. If you've ever been in a manufactured home, you know that you can push them. They're flexible. There's a hat hanging on the coat rack, and that mirror is perched against the wall there. Mr. Cummings testified that he believed that the heater was on the wall. There's no scratches on that wall. If they were in this big battle for their life and they knocked over that heater, wouldn't the wall be scratched from the heater being knocked over? There's no physical evidence of a fight. On the other side of the room, clothes are hanging still. Not a little bit of clothes. It looks like a lot of clothes on that hanger. The lid of that plastic bin is precariously open. That wasn't disturbed either. Now, let's talk about this photo. You heard Mr. Brudenell, the expert, testify that the shooter must have been either between the two beds, the bunk bed and the other bed, or over by that wall. So he said that the shooter must have been here, or here.
Break out the Sharpie.
Not a lot of space. If this is our room here, and we have two beds, a bunk bed here and a bed here, there's not a lot of space. There was a struggle. That stuff would have been disturbed. Something would have been knocked over. The expert testified that Mr. Adiola must have been parallel to the floor. He could have been on all fours. That's a vulnerable position. He's not fighting anybody on all fours. But the wounds show it. He was shot right to left. So that's why the shooter would have been here on this side, right? Right to left. And from an upward position downward. The trajectory was downward. So that means the shooter is raised above the person who was shot. So Mr. Adiola could have been on all fours. You heard that. That's not someone who's fighting. That's not self-defense. Someone on all fours. Or he could have been bent over. Again, that's a vulnerable position. You're not fighting someone if you're bent over and they have a rifle pointing at you. Mr. Brudenell says that, and OMI says that. They both said the same thing. The decedent could have been on all fours or was bent over. That's what the evidence shows.
They also said it was unlikely that he would be sitting up on top of the bunk bed where he'd have to be fire in that position.
The defendant, in his reenactment to you, ladies and gentlemen, he said that Mr. Adiola was coming at him, and he was crab walking, holding the gun, fighting him off. Crab walk. He's fighting him off, and he's the one on the ground. And in his reenactment, he said that Mr. Adiola was standing above him. That's not what the evidence shows. The evidence shows a downward trajectory, not an upward.
In New Mexico, it's still the law. You have to wear a face mask in the courtroom.
The shooter was above.
They haven't changed that yet.
Being shot. That's a vulnerable position. Let's talk about the mace. No witness ever said the mace was sprayed. Mr. Cummings said maybe. He was kind of unsure, and on redirect, then he said it was sprayed. He's the only one who said that. This is a self-serving statement. There's no physical evidence to support this. Mr. Cummings didn't even call it mace. He called it a neurological agent, or chlorophyll, or poison. Law enforcement testified that they've been sprayed. They do this as part of their job and training, that it could last anywhere from 45 minutes to 2 days. And you heard a lot of this in voir dire. It gets on your clothing. And they also said that an excess will drip out when it's sprayed. There's no excess. None on Mr. Adiola's hand and none on the floor. It has a distinct smell. And water could reactivate it. Mr. Cummings said he washed off with the hose spigot. He's just spreading it. When you put
And
water,
soap.
it just spreads it to other parts.
Because the water
He said he
didn't
used
work.
soap and washed more. You heard testimony that Mr. Adiola was known to carry mace with a dye. It's probably not the same can of mace from that 2017 incident. He probably got another can.
I think he had a lifetime supply of mace.
There's no red dye in that room. And you can look at the can of mace. It appears that there's a red dye, and I encourage you to look at it. There's dirt in there. This hasn't been used. Mr. Cummings set up this scene so that he can claim self-defense, to justify his unreasonable actions. Mr. Adiola was not armed. This can is facing the wrong way, and in order to utilize this can, you have to lift
Show
up
us,
the
show
top
us.
and then spray.
Yeah,
There's
go
no
ahead.
way you could do that from that position within the can.
Go ahead and fire it off in the courtroom. At the court
No
clerk,
one falls
apparently.
over with something in your hand. If you're going to fall with your hands out to brace your fall.
Unless you're
You're not gonna
dead
fall with something in
when
your
you fall
hand.
over. Which I believe he was.
If someone is shot, they likely grab whatever area they're shot at and they go forward. If Mr. Adiola was shot to the head first, You heard OMI that would have been an instant kill. He wouldn't have survived much longer after that.
No, instant.
If he was
not
shot
at all.
to the head first, he would have been fallen face first and not likely to hold anything in his hand. Let's talk about Dr. Gerald, the OMI doctor. She said that Mr. Adiola was 5'9", 199 pounds. And he's supposedly in this fight for his life with a professional athlete. Mr. Adiola had 2 gunshot wounds. The first one she talked about entered at the right temple, went through the oral cavity of the neck, broke 3 cervical vertebrae, and left fragments in the chest. And the second shot, she said, was to the supraclavicle region. I'm not good with the science terms. And it exited out the other side of his chest. The first one was, she said, an
just
intermediate
important
range.
details.
And the second one was a distant range. Dr. Gerald said that those injuries were from right to left in a downward trajectory. The shooter was above Mr. Adiola. She said Mr. Adiola could have been kneeling.
I think that's what they're trying to say.
Other than the injury to Mr.
was
Adiola, he
planted.
had an injury to his nose. He had some bruising she could not age, I believe she said, on the back of one of the thighs. And you have the body diagram. But other than that, he had no scrapes. He had no injuries from this fight. His knuckles aren't damaged from a fight. There's no scratches. There's no abrasions. Nothing of that nature.
So Ola's got some countering evidence.
He has no burns on his hands from supposedly grabbing a hot barrel. The expert said that the rifle barrel, when it's shot, it's a ball of gas essentially coming out, and it would have been hot. You also heard from Dr. Gerald about the toxicology, that Mr. Adiola had cocaine, alcohol, and marijuana. There's no information. She couldn't tell you how that would affect Mr. Adiola particularly. She just said it could cause aggressiveness and it could cause risk-taking, but she couldn't say how it affects one particular person. And she admitted she has no knowledge of how the testing process goes, and she was just reading what potentially could happen to someone from a piece of paper.
That was basically all of the prosecution
pen
evidence.
And papers.
Potentially
Again, this
this
stuff
happened.
wasn't tested. There's no evidence. You heard that it may be consistent with drug use. Let's talk about the DNA. Jennifer Otto of the New Mexico Department of Public Safety Lab, she did serology testing. That's testing of the bodily fluids. And
They're-
she said that the
They're saying it was over
clothing
the
Mr.
land,
Cummings wore
the land deal.
was tested. His clothing that he said he wore at the time of this, that was wet when it was collected, had no blood on it. So that means that he was standing far enough away from Mr. Adiola when he shot him that there wasn't even any blood on his clothing.
You wouldn't expect blood on his clothing from the rounds he was using and from being in
Let's
front
talk
of the
about
target.
the DNA testing she did. She said that she tested the rifle, and Mr. Cummings' DNA could not be eliminated. But there was a mixture there, so he could potentially be there. But Mr. Adiola was eliminated as a contributor to the DNA. And you heard about the different areas of the gun that were tested, and you saw the reenactment from Mr. Cummings when he said, yes, Mr. Adiola was grabbing everywhere all over the gun. He tested multiple areas of this gun, and Mr. Adiola's DNA was not on this gun. He didn't touch this gun.
Say his DNA was not on the gun? Or his fingerprints? I didn't hear. I could not hear what she said.
The
They
mace
tested
can.
it, and his
There's 2 DNA
something wasn't on the
contributors
gun.
mace can. Mr. Adiola was the major DNA contributor, and Mr. Cummings was eliminated. If Mr. Cummings had time to set up the scene, he could have wiped the can like you see in movies and then put it in his hand. Just the way he wanted everyone to witness the can in the hand. They took swabs from Mr. Cummings' face and hands. There were 2 contributors. Mr. Cummings' DNA was there. Obviously, it's his body, his swabs. That's not a surprise. But Mr. Adiola was eliminated. This was a physical fight Mr. Adiola's DNA would have been on his face or his hands if they're fighting for the gun. They also tested the fingernail clippings for Mr. Adiola, and there was no DNA foreign to Mr. Adiola. So that means Mr. Cummings' DNA wasn't underneath his fingernails. There's not a fight. That's not a surprise. Let's talk about Lieutenant Tomlinson. He testified about the limitations of their radios and the CAD system and the body-worn cameras and belt tapes, and that Sandoval County is the largest geographical county, and they typically on a normal shift have 4 to 5 deputies for this huge county to cover on every shift.
These are all possibilities, Chandra.
You heard him say
Gotta
that he
consider
testified at grand jury on March 19th, 2020, and he was asked on cross-examination, how can you say that drugs and alcohol were not an issue when he was asked this on cross-examination? And you heard him. This grand jury was on March 19th.
I got hot
He didn't
chocolate
have
from my wife.
toxicology. He didn't know. He can't say that it was. He didn't have that information.
Apparently, she wants me to spill that on the laptop,
He
too.
didn't have Agent Herrera's report. Agent Herrera's report didn't come out until April 7th. And Lieutenant Tomlinson also testified that he believed Mr. Adiola entered the room, bent and turned the other direction, entered the room, bent and turned the other direction and went to leave, and that's why the body landed in the position that it landed. Because of momentum.
It's too late.
He also testified that Mr. Cummings also had marijuana. And he was in the presence of Mr. Cummings for 6 hours, and he also saw no injuries. You also have to determine that this wasn't self-defense. And the evidence shows that this was not self-defense. The only one who says it's self-defense is Mr. Cummings, who wants everyone to witness the can. You saw some photos about splotches on a gun. Agent Herrera said it could be stifling gun residue. It could be cleaning oil, Agent Herrera said. The expert said it could be cleaning oil. Sergeant Griffin said it could be cleaning oil. If the defendant had just taped on the scope with electrical tape, he could have cleaned the gun. There's no evidence whatsoever what those splotches are.
He didn't tape on the scope with electrical tape.
Even the mace.
My video,
There's no
the feed
evidence
seems
it
to be
was
good on
ever
this side,
sprayed.
Patty. Is anyone else having trouble?
The self-defense instruction says that you need to determine whether or not there is an appearance of immediate danger of death. Does this give the appearance of an immediate danger of death or great bodily harm? Would a reasonable person believe you're in immediate danger of death?
I'm going to be careful, I promise.
The muzzle patterns, you heard the expert testify, they can't be aged.
You guys are
There's
so
no way
bad.
for him to tell if they were hours apart, days apart. If Mr. Cummings had time to put this in Mr. Adiola's hand, he had time to put those marks in the ground. There was hours unaccounted for. He didn't go get help. He didn't drive 4 miles down the road to get cell phone service. He was there for hours.
Hey, John, when we get a break, I'll catch you up on where we're at with this. We're in closing arguments
Mr. Cummings,
right now.
when he testified, he showed you his reenactment. This is how small the room is. Nothing's disturbed in that small room. He said he was crab walking. He said that he was pulling Mr. Adiola by his jacket.
He was pulling him by his
Mr.
jacket.
Adiola doesn't have a jacket. There's no jacket collected. No jacket was ever mentioned until Mr. Cummings said that. Mr. Cummings said that Mr. Adiola pulled the barrel of the gun
She just got a
against his
text.
trigger finger. How reasonable is that?
Very reasonable.
If Mr. Adiola is pulling the gun by the barrel against his trigger finger, he would have burns on his hands. His hands would have been shot. How reasonable is Mr. Cummings' story that someone's going to pull the gun against your trigger finger?
I think the problem is the prosecution is not familiar
His
with
story is
firearms.
not reasonable. His story. It's a self-serving statement made up to justify what he did, and you determine the credibility of the witnesses. His story contradicts everything that every other witness said, every piece of audio we have. This is not self-defense. It requires that he was in fact put in fear by the apparent danger of immediate death or great bodily harm. And mace is not that. There's no immediate death. There's no great bodily harm. His actions weren't reasonable. And we would ask that you find him guilty of the second-degree murder because he was not provoked. Mr. Adiola was unarmed
She's wrapping up.
when he shot and killed him.
But it's a weak wrap.
Or the lesser included offense if you think he was sufficiently provoked of voluntary manslaughter. Thank you.
She should have ended with an apology. You're going to hear a markedly different presentation here, as the defense is going to have a lot more energy in their presentation. Oh no! We're not getting the person I thought we were getting. The one on the defense attorney that's sitting closest to us. She's the fiery one. It looks like we're not going to get her. I think the prosecution did about 50 minutes on their closing arguments.
Counsel. Ladies and gentlemen of the jury, it's almost like the prosecutor was watching a different trial than the rest of us. Because the state's case, after all of this evidence has been presented, boils down to a bunch of could-haves, hypothetical scenarios, and excuses. Excuses for why they didn't do the criminal investigation that should have been done in this case. The type of criminal investigation that the state has an obligation to do. Because the state, the law enforcement agencies, and we've got two of them in this case. We've got the Sandoval County Sheriff's Office, and we have the New Mexico State Police. Two agencies that could have and should have done a thorough, unbiased investigation. And instead, what we have is this half-hearted, sloppy, I'm sorry to say it, sloppy, incomplete investigation. And now the state's asking you to prosecute and convict Mr. Cummings of murder? Let's talk about what the evidence actually showed in this case. The evidence that you saw during this trial. The state started its case with Officer Walker. Officer Walker, who seems like a nice enough guy, but he had spent his entire law enforcement career skipping from one agency to another, to another, to another, until now he's not even in law enforcement anymore. Officer Walker sounds like the first person who had contact with Mr. Cummings that day. When the police finally arrived on scene, took them a while to get there. Mr. Cummings waiting patiently for them to arrive. And Officer Walker testified on direct examination that Mr. Cummings refused to provide his name, and that he had asked Mr. Cummings his name and he wouldn't tell him. As you may recall, my co-counsel asked him to listen to his entire bell tape. We took a break for the night, at which time he did. And then he had to come back into court and he had to tell you, he had to admit that his statements were not true. He actually never did ask Mr. Cummings his name. So that's our first state's witness. He also denied that Mr. Cummings ever said, "I'm devastated." Denied that he ever said that. And my co-counsel, again, had to play his recording back to him so he could listen to it, and you could all listen to it again, when it is as clear as day that one of the first things that Mr. Cummings said to those law enforcement officers is, "I'm devastated." And yet the state wants to spin it like he was having no emotions at all that day. The state ignores the fact that during the 911 call made by Mr. McCullough actually says that Mr. Cummings seems pretty shook up. It's in the 911 calls. You have them. If you want to listen to them during deliberations, you may do so. So even Mr. McCullough says he seemed shook up, and then he describes himself as devastated. But I'll give Officer Walker credit. At least he was running his belt tape. At least he was running that recording device. Because in this case, I think it's become really clear why it's so important that law enforcement have recording devices whenever they interact with the public. It's so important because just with Officer Walker, we saw all these numerous inconsistencies and inaccuracies in his testimony that he had to be confronted with using his belt tape. And so at least he was running it. Another law enforcement officer ran a recording device out at the scene. Officer Crespin says he was running his lapel camera. He says that he was running it and he made multiple videos throughout his investigation that day. And yet somehow, oddly enough, that is the one case where his videos disappeared. He told you about how he would download all of his videos once a week. And he admitted that all of the videos from that week, that included February 29th, all of the other videos from all of his other calls that week were downloaded. Crazy. All of the videos just for Mr. Cummings' case disappear. No explanation for that, and I don't have an explanation for that. Either he was not telling the truth when he said he was running his camera, or they were destroyed or lost. Officer Crespin is also the officer who doesn't even know what time the sun sets. He couldn't even tell us accurately when the sun had set the day before. And so the state wants you to take his testimony and believe that he actually was interrogating Mr. Cummings and asked him for 3 hours what his name was, and that he didn't know his identity, despite the fact that Mr. Cummings had actually called 911, had given his name, had given his phone number, and told the 911 operator, "I have been attacked." Attacked. Where's the 911 call Mr. Cummings made? Why do we have 4 911 calls from Mr. McCullough, and we don't have his? We don't have Mr. Cummings.
Objection, Your Honor. Reapproach.
Interesting. Where's his call? Karma caught up with the serial macer, says TW. Another case of the video wasn't working. How convenient. She can rest her case. Okay, I think, who was it back here? Somebody had asked where we're at. Oh, it looks like we're not getting enough time to...
As I was saying, the state never even obtained Mr. Cummings' 911 call. Why not? They can clearly get 911 calls because they got Mr. McCullough's. Why not get his? Then moving on to Sergeant Griffin. Sergeant Griffin was the investigator at the scene responsible over the investigation of the ranch. Sergeant Griffin came in here, ladies and gentlemen, and told you this was the magazine recovered from the scene, and these were the casings recovered from the scene. Their lead investigator on scene tells you this. It's not a big mystery that this is not the right magazine. This is the right magazine. Why do we have 2 magazines? The state doesn't even know what their evidence is, and we don't know where this stuff comes from.
Your Honor, I'm going to approach. I'm sorry, but this is really unfair and prejudicial.
This makes us look really bad. Can we make this stop for some reason? I'm losing my election and this court case. Yeah. Okay. So this the defense is laying out the case pretty well. I don't think the judge is going to side on the part of the defense here, because we have a witness who openly testified that a police officer is responsible for gathering evidence of the scene, who said, "I don't know where that came from. I don't know where that case came from. That magazine came from." let's see how this ends. You can tell how the judge rules by the line of questioning they continue on when they're done. They're not friends. They are not friends. See if she picks up the magazines again. She does. Yep.
This is the magazine. We know this because Mr. Cummings told them exactly where they would find it, and that's exactly where they did find it, on the porch steps. That's Sergeant Griffin for us.
She probably was told not to talk about the state, the attorneys.
Sergeant Griffin also testified that Mr. Cummings told him where his clothes were located, told him he had been attacked and sprayed with some kind of a chemical, and asked him to tag those pieces of clothing into evidence and to test them. To test them. None of that was done. The testing, obviously. Then we hear from Officer Herrera with the New Mexico State Police, our second law enforcement agency on scene. Officer Herrera described how when he went out to the scene, he did some preliminary investigations. We see the photos that were taken. We see the evidence markers. And we see some trajectory rods. What we don't see, though, is a complete shooting reconstruction. The state never did that. They have people, they have a whole Department of Public Safety that could have done a shooting reconstruction. Why didn't they do it? Instead, it was left to the defense. We had to hire a shooting reconstruction expert, Aaron Brudenell, and ask him to try to piece together the scene based upon what had been collected by the state police and by the Sandoval County Sheriff's Office. But a lot more could have been done at the scene, and it wasn't. And ladies and gentlemen, I would submit to you that the reason the state didn't do a complete shooting reconstruction is because it wouldn't have helped their case. Because once we saw the complete shooting reconstruction, we see that it actually proves Mr. Cummings is telling the truth. I apologize, I should have gotten this set up before I started.
Judge has to turn it on too. Judge has the switch.
So what we see once we finally do a shooting reconstruction is a scene that is chaotic. A scene with impact sites showing that this gun was on the ground upside down when at least 2 shots were fired. Who intentionally kills somebody by laying on the ground, turning their gun upside down, and shooting? The state seems to be trying to suggest that Mr. Cummings could have done that after he shot Mr. Arreola. Again, could have, without an answer is reasonable doubt.
Nailed
It's
it.
also ridiculous, quite frankly. And you heard Mr. Brudenell explain why that scenario was incredibly unlikely. You would have had to have pretty much laid across the body in order to achieve that. And as the state pointed out in their own closing, there was no blood on his clothes.
Yep.
So how is he laying across Mr. Arreola's body when he's lying there bleeding out, shooting this gun off at this incredibly odd angle and location, and not getting any blood on him? Again, this is just sheer speculation by the state. Moving on, our case agent, Lieutenant Tomlinson. Lieutenant Tomlinson oversaw this entire investigation from his office. He never went to the scene.
He's a desk jockey.
He never bothered to order the testing of Mr. Cummings' clothes. He never bothered to have the gun tested for traces of mace.
Or tasted.
He
probably
never
didn't do
even
that
bothered to speak with Carlos Herrera, Instead, he went before the grand jury and he testified to a series of statements that were not true. He then comes in here and testifies before you all and explains that he was in a coma last year and therefore he can't remember his grand jury testimony. But he can remember the details of his investigation just a few weeks earlier. And whether he can remember the grand jury testimony, whether he can remember the investigation or not, doesn't really matter. Because the fact that he may have been in a coma a year ago doesn't explain his lack of investigation 2.5 years ago. It doesn't explain his grand jury testimony 2.5 years ago. We also heard from Dr. Jarrell at the Office of the Medical Investigator. Dr. Jarrell is a professional. She is a forensic pathologist. She comes in here and testifies as to the facts as she sees them. What she did not do was testify that Mr. Areola was on his knees. She did not testify that the shooter was over Mr. Areola. In fact, she said she doesn't know where the gun was. She's not going to speak to where the shooter was. All she could testify to is the trajectory of the wounds and basically the toxicology results. She told you. She also never testified that Mr. Areola would have dropped that can of mace when he was shot. There was never any testimony about that. That is all the state, spinning the facts to suit their needs. What Dr. Jarrell did testify about that is important, I think it's very clear why it's so important now, is the fact that Mr. Areola was intoxicated. He was a .118. For context, the legal limit for driving while drinking is a .08. So Mr. Areola was over the legal limit for alcohol at the time of his death, and he was using cocaine, and that the cocaine and alcohol were used close enough in time that it actually combined to create a different substance called cocaethylene. Cocaethylene in the body can increase aggression and risk-taking. She testified to all of that. And then we heard from the state's DNA analyst, Ms. Otto. Ms. Otto testified that Dean's DNA was found on the gun. Of course it was found on the gun. That makes sense. It's his gun. He never denies handling it. She also testified that when they tested the gun, when they're swabbing it, looking for DNA, they didn't swab the scope at all. They didn't swab the muzzle at all. All of their swabbing was focused down here, which is consistent with what Mr. Cummings was saying, where he was holding the gun and where Mr. Areola was grabbing for the gun. Mr. Areola was grabbing for the gun here and here, ripping the cap off the scope. So no wonder they never found Mr. Areola's DNA on this firearm. They didn't test the right places. Mr. Cummings' DNA is never found on the mace canister. And by contrast, this is small. This is compact. Ms. Otto testified that when they would swab something like this, they would have swabbed the whole can. They were able to get all around it because it's small compared to this. And Mr. Cummings' DNA isn't on here. Mr. Areola's is, of course, because as we now know, Mr. Areola loved his can of mace.
He loved his mace. That's the truth. Everybody wants to hold up the gun. We also heard from Mr.
McCullough and Christine Landers. Mr. McCullough came in and he told you what happened that day to the best of his memory. testified that Mr. Cummings was pretty shook up. We have no dispute with what he testified to. Ms. Landers, you heard her testimony. You will ultimately be the judges of credibility. Ms. Landers, it appeared
I'm having network issues.
that she was looking for a quick buck. She wanted this real estate contract signed quickly. She didn't want to bother with other agents or allowing Mr. Cummings the opportunity to speak with a lawyer. She wanted him to sign that contract that day, right away. She was even annoyed that he read the contract. She didn't even want him to read her contract, and she certainly wouldn't give him a copy of it. She also claimed she knew Mr. Areola for over 20 years. Apparently, she didn't know the same Mr. Areola that everyone else did.
Had she been maced? That's what we want to know.
Because let's talk about some of the people who really knew Guillermo Areola. Debbie Dominguez and Joe Chavez. And remember, these are people that don't know Mr. Cummings, never met him before. They came in here yesterday and they talked to you about the real Guillermo Areola. How they were both maced. Multiple members of their family were maced.
The lady on the rail,
guy in that mace,
who's moving right now,
he even
she helps
maced
in the courtroom.
their dog. And then you hear from Mr. Klinger. Mr. Klinger, who doesn't really know anybody. Doesn't know anybody. He was just there to buy some medical equipment.
There's a disturbance in the courtroom. The bailiff
Mr.
stood
Klinger's
up to
only
check it out.
connection is the fact that he had done a couple of transactions with Joe Chavez for sounds like some kind of medical devices or some insulin because they both were diabetic.
Hey, Jay.
And he testified that he had just pulled up to the gate and was waiting to be let in when all of a sudden Mr. Areola comes up and starts attacking his car with a hammer. A hammer. Never met the guy before in his life, and Mr. Areola breaks out his tail light and is banging the hammer all the way down the side of his car. He gets out to say, "What are you doing?" And Mr. Areola holds the hammer back and says, "I'm going to F you up." That is the real Mr. Areola. Unfortunately, that's the Mr. Areola that was out at the ranch that day. That's the Mr. Areola that attacked Mr. Cummings. Mr. Chavez made a statement when he testified yesterday that really struck me. And I'd submit to you, ladies and gentlemen, to consider this. Mr. Chavez said that Mr. Areola was only aggressive when he was drunk, or when he was intoxicated. But he was intoxicated every day. That is the Mr. Areola that attacked Mr. Cummings.
You guys having the buffer issue? It seems resolved
Mr.
on my
Cummings
side.
got on the stand and testified and told you all what happened. He also told 911. He told Mr. McCullough. He told the police when they arrived on scene. And he told you that he acted in self-defense. Can't see this too well, but you will be able to see it when you go to deliberate. This will go back with you. This is the instruction for self-defense. And what I want to point out to you, ladies and gentlemen, is that the burden is on the state to prove by a reasonable doubt that the defendant did not act in self-defense. The burden is on the state. It's not on us. We don't have to prove he acted in self-defense. They have to prove he did not. But ladies and gentlemen, I would submit to you that not only did we prove beyond a reasonable doubt, we proved beyond all possible doubt that he acted in self-defense. Let's talk about what the evidence shows there. Mr. Cummings described for you when he testified, the relationship that he had with Mr. Areola. He described that they got along pretty well. They spent a lot of time talking about the ranch. They went horseback riding together. They even spent a night drinking whiskey. Of course, it was the night that the two of them were drinking whiskey that he started to see some red flags with Mr. Areola, when Mr. Areola started to share stories about his neighbors. Now we can see why Mr. Cummings would have been a little bit apprehensive about getting crossways with Mr. Areola after hearing the stories about those neighbors. But Mr. Cummings tried to continue to get along with Mr. Areola because he wanted to buy that property. He really wanted to get that land, and he wanted to build his home and his guiding company. He had no motive to kill him. Killing Mr. Areola kills the land deal.
This is true.
So the state cannot present to you any sort of a motive for why he would have killed him. And you don't have to take Mr. Cummings' word on how things happened that day, because the physical evidence actually does show you that he acted in self-defense.
Okay, there we might have some
First,
graphic pictures here.
Starting
Just
out in the
warning.
kitchen, the state's trying to direct your attention over to like the living room area and saying there's no sign of a struggle in the living room. Well, of course there's not a struggle in the living room. We all have heard the struggle never happened in the living room. I don't know why they keep trying to direct your attention there. But what we do see are Mr. Areola's sunglasses laying on the floor right at the location where Mr. Cummings said this all started. Right where he was attacked for the first time, right here, next to this counter. And he's described for you when the very first time Mr. Areola attacked him, he went down on the floor. He didn't go flying over to the stove. He didn't go across the room to the living room and start tearing that up. No, he went into the hallway. And he described for you how when he went down, his firearm happened to be sitting right about there. His firearm that he was preparing because he was going to go hunting. And when Mr. Areola attacked him and was over him, he grabbed the firearm away from him. He grabbed it away from the wall in an attempt to defend himself. And he described for you how the fight went down the hall, how he was knocked down again by the bathroom, and he tried to get up, and he did get up, and at that point in time, he held the rifle and pointed it at Mr. Areola and said, "Stop." He was trying to stop this attack, but Mr. Areola didn't stop. And the state's arguing that's not what a reasonable person would do. That is correct. That's not what a reasonable person would do. But what we all know now is that Mr. Areola wasn't always a reasonable person, especially when he was drunk and on cocaine. Far from being reasonable. The fight continued into the bedroom, and we hear about how he was tackled again. Tackled again for a third time in the doorway of that bedroom. And what do we see? What do we see there? The state says there's no physical evidence of any sort of a struggle. What do we got right there? We've got a propane heater knocked off the wall. We see the brace that holds that heater up. Knocked off the wall, laying on its side in the bedroom. What is that if not signs of a physical struggle? And then the struggle continues in the bedroom. And as we've already heard, ample testimony, and we've seen the impact shots.
Okay, here's you start seeing some blood in these pictures, so look away if you don't like these.
Two shots go off with the gun upside down on the floor, completely indicative of a physical fight over that gun. A struggle for the gun that's going to result in one person living and one person dying. Mr. Cummings did not want to be the one who died.
I think it's important to see that those shots were fired
A
on the ground.
physical fight
that
where
were under
Mr.
his
Cummings
body.
is retreating away from Mr. Areola back into that tiny bedroom. And the state's going to make a big thing about how small that bedroom is. Ladies and gentlemen, I submit to you, that makes it all the more credible that Mr. Cummings would feel in danger for his life. He wasn't in some big room that he could retreat even further, which, by the way, the law in New Mexico is that you do not have to retreat. You can stand your ground. But despite that, he did keep retreating. All the way down the hallway, he kept retreating until he gets to this tiny little room where he can't go any further. He can't go any further. He is trapped in that room with a crazed man attacking him over and over again. And you could see the rug pushed up, bunched up, to where Mr. Cummings couldn't go any further. He had nowhere else to go. The gun is already going off. It's already shooting stuff all over the place.
Sorry, I got a text. She got a text.
The gun's already been shooting bullets all over the place. As you hear from Mr. Brudenell, it was a chaotic scene. We have at least 3 different angles of gunshots at that scene, indicative of a struggle. And finally, what we have in this photo, you can see where the scope cap was ripped off the rifle and ends up under Mr. Areola's body. Ripped off under his body. That's critical. That is completely consistent with what Mr. Cummings described as how Mr. Areola was pulling on that gun, trying to pull it away from him, pulling on the scope. And he's pulling so hard that it doesn't just tear the cap off, but there is electrical tape to make it even more secure. And it breaks the cap. It breaks the cap and lands under the body. And finally, what do we find in Mr. Areola's hand? A canister of mace. The state is trying to make a big issue out of the fact that Mr. Cummings was describing it as a poison. Maybe he called it a poison. Neurotoxin, chlorophyll. If Mr. Cummings had planted the mace in Mr. Areola's hand, wouldn't he know what it is? Wouldn't he say there was mace in his hand? Instead, he's describing it all these different ways because he doesn't know what it is. All he knows is that there was something black and hard that he was being attacked with over and over and over again. Because we know now, Mr. Areola liked to attack people with mace. Now let's talk about Mr. Cummings' behavior after the shooting. Mr. Cummings immediately ran out, washed his face, washed his hands, still burning. That's consistent with the testimony we've heard that water isn't a good way to treat mace. He didn't know that. So he ran inside and got some soap, came out and continued to wash his face. Took a while for the burning to stop. But once the burning stopped and once he could breathe again, what did he do? Ladies and gentlemen, I would submit to you that every action Mr. Cummings took after this shooting are the actions of an innocent man. We're out in the middle of nowhere. There's nobody around this ranch. If he had actually just murdered Mr. Arreola, why didn't he just leave? No one's there. He could just say, I have no idea what happened. Why did he stick around? Why did he wave down Mr. McCullough? Why did he call 911? Why did he wait hours for the police to arrive? Why did he gather up his clothing and put them on the bed of his pickup truck? Why did he put the gun and the magazine on the front porch steps? Why did he do all of that? He did all of that because he acted in self-defense.
The defense was looking over at the jury, looking to see how they accepted that comment.
The state's making an issue out of the fact that he asked Mr. McCullough to be a witness for him. He explained to you why he wanted a witness. He was scared. They were out there in the middle of nowhere. He had just shot a man. He knew that police were going to arrive because he asked the police to be called, and he called the police himself. He knew that when the police came out there, they were going to be on edge. That's reasonable. He knew they were going to have guns drawn on him. So he wanted a witness not only to what had happened at the ranch, but he wanted somebody there to be a witness to the police. And Mr. McCullough was that. Mr. Cummings did everything he could to assist the police in their investigation. Despite everything he did, the police still didn't do a complete investigation. They gathered the clothes, but they never test them. They take the gun, but they never test it for mace. They never even tested the mace canister. They never even called the mace manufacturer to ask if this had dye in it. The state's asking you to look at this mace canister and decide that it has some kind of dye in it. There's no evidence of that. And in fact, this looks more like rust than any sort of a dye.
Spray it.
And the testimony we've heard from the two people that actually were maced by Mr. Arreola is that the mace he used didn't have dye in it. But regardless, the state could have tested these things. The state actually did do a little bit of testing of the firearm. You heard Mr. Brudenell describe for you how they did some basic firearm testing to make sure that it operated. They tested the gun to make sure it worked. How is that helpful? What does that tell you about this case? Nothing. We already know the gun worked. He just said he had used the gun to shoot Mr. Arreola. So that wasn't in dispute. All that shows you is that the state is capable of doing testing. They just chose not to. Ladies and gentlemen, the state has the burden of proving beyond a reasonable doubt that Mr. Cummings did not act in self-defense. All of the evidence in this case, all the physical evidence, everything that you have seen corroborates Mr. Cummings, corroborates the fact that he was attacked. He was attacked not once, not twice, not 3 times. Repeatedly, over and over and over again. He was attacked by Mr. Arreola till the point where he was up against almost a wall. He was up against those beds with this man over him, still coming at him. Still coming at him. And that he scrambled up to his feet, and you see from the way the rug is all bunched up right where all of this happened, he's scrambling to his feet, pulling on the gun, and he even tells you how at one point he decided, Dean, if you don't get serious, you're not going to be a dad anymore. And he then takes his other hand, his left hand that he had been using to block Mr. Arreola's strikes. At that point, he realizes, this is it. This is it. I need to get serious or I'm going to be dead. When that happens, he grabs the gun with his left hand, raises it up, and shoots at Mr. Areola as he's coming towards him again. The trajectory of those bullets shows that right to left pattern in a downward position that is completely consistent with someone attacking. He was attacking Mr. Cummings at the time he was shot and killed. The state tried to suggest that Mr. Areola was an old man. He wasn't an old man. He was 47 years old at the time of his death. 47. Younger than Mr. Cummings. Ladies and gentlemen, the state's going to make their rebuttal closing, and then the case goes to you. At that point in time, the power is going to shift. The power that the state has and law enforcement had when they conducted their investigation shifts to you. And then you have the power to review their investigation, review their prosecution. And you have the power at that point in time to take the facts, look at the law, and render a verdict. And I would submit to you, ladies and gentlemen, that all of the evidence in this case points to only one verdict, and that is not guilty on both charges. Thank you.
That was textbook. That was beautiful. She went through every step. She ripped them apart, left the jury nothing but doubt. Let's see how they sum. They've got like 10 minutes here. For our next number, we will sing. Do you want to do it? No, you do it. Oh my goodness. There's a bad audio connection. It's got a hum.
The defendant said, there is no future without fear. This is a man who sees right now, almost. Very dangerous.
You can't hear. They're talking about him skiing. I can crank the audio, but that hum's just going to get louder. Oh, can't pan too far.
Either. Very light. Would you ever feel it? But he was so afraid, even though he was blocking it, why couldn't he knock it out? Very light.
Watch her spray this. Watch her spray the jury with mace in closing arguments.
And Ms. Moss also asked, why would he say it was a neurological agent? Why would he say it was poison? Well, I suspect he's figured out, and Sean has figured out, because mace is not a deadly weapon. And for his self-defense to work, he had to have said it was something other than deadly, something that was a deadly weapon, like poison, or a neurological weapon or agent. That's the only way he could justify using this to repel this. And you'll get a chance to feel this weapon. Very heavy. You heard his testimony. You saw his demonstration, which did match the testimony, by the way. And you ask yourself how he could have been holding this upside down, crawling away, and this would have had to been on the ground. That's what he said. He's using this to crawl backwards. And he's still blocking with this. Well, how is Mr. Guillermo even getting the weapon if it's so close to the floor? Was he all the way down trying to get the weapon? You don't know, because he couldn't explain that. He just kept saying, that he was owed me. He kept trying to hit me over, over. And you will recall in Ms. Moss' opening statement, he testified a little bit, excuse me, differently than what she said happened.
There she goes again. Oh, man. A good shotgun mic, that's actually the name of it, would fix this. It would pick up audio from wherever the camera's pointed.
He was being struck with this thing, and Mr. Ariola's hand over and over and over again. Words matter. And what he said and didn't say also matters. As the state, we always have the burden of proof. We gladly embrace that burden. And I will say, the defense team did a great job, outstanding job. Mr. Cummings did nothing about it.
Did she say the defense did an outstanding job?
But when something doesn't make sense, it's not true. And they don't have to put on a case. But once they do, once he takes that witness stand, the same instruction you use for credibility for the witnesses, you use for him. You take into account his truthfulness. Well, I disagree a little bit with Ms. Moss. Nobody can prove 100% or beyond a reasonable, or beyond all possible doubt of that.
Whoops.
That's why that's not the instruction. Because there's only two people that know what happened. Two. The defendant and Mr. Ariola. And he's not here to say what really happened. Let me tell you, if you want to talk about possibilities and scenarios, the evidence doesn't necessarily show what they're saying.
Even her argument
This
is
is how small
phrased
that
weird.
room is. And keep in mind, there were bunk beds along this wall, right? He comes in, and there's a bunk bed down there, and there's a coat thing down there. It's more likely that Mr. Adiola said, hey, where the hell are you? Or where are you going? Why are you going to the bathroom? Comes in, bang, bang, bang. What's the person going to do when they hear shots? And both his expert and OMI did say that it could have happened, and he could have been, Mr. Adiola could have been on his knees. And when he was down here demonstrating, and I think I asked him twice, when you actually shot him, show me, how was the weapon?
Where's the blue
By the
gun?
way, just so no one gets nervous, I was well aware yesterday that the weapon was cleared because officer and I tested it. But he was pointing like this. He was pointing out because he had to for the story to make sense, right? Because Mr. Adiola is still trying to do this. He's leaning over him, striking him, and he said he'd do like this. That does not match the evidence. There's no dispute. But the two gunshot wounds that killed Mr. Adiola were down, slightly down, and to your right.
She's looking at her time. How long do I have to stall for before I can just be done?
There's no way that if he was coming straight at, Mr. Adiola was coming straight at the defendant, there is no way that he could have been coming straight on to get this shot and this shot. Wrong side. This shot and this shot. No way. And why the room is small, that's important for a lot of reasons. He's scooting back. Explain if he was scooting back.
She puts it down,
He's
picture
scooting
down,
back.
like a copy machine.
And he fell, and the defendant certainly didn't indicate that he moved the body. He fell right there, he said, at his feet.
There was no blood
It's
evidence
not
that the
even
body
in
was
his
moved
room,
either.
And he would have had to have been up higher. And if he was really at his feet, common sense, ladies and gentlemen. Look at all that blood. You tell me how it would be possible
Don't look.
that he wouldn't have gotten blood on himself. On his hands, on his shirt. That room was small.
The camera's trying to avoid the video above and below that show the
Where you believe
the
he
graphic
was when he shot.
wounds.
But we know one thing for sure. We know that the shooter, the defendant, had to have been above, or at least the weapon had to have been above Mr. Adiola when he was shot. That doesn't fit his theory. Red herrings. I'm sure y'all know what red herrings are. It's when there's things thrown at you or put in front of you to distract you from what's real. You don't look at the things that don't make sense. You don't look at all the times that he told me he couldn't remember. When I would ask him about stuff that he knew clearly didn't make his story work, I don't remember, I don't recall. In fact, I believe a total of 22 times. I don't remember, I don't recall. Mr. McCullough said you didn't tell him right away. I don't recall that. Mr. McCullough you were talking to somebody else and the conversation was going, I don't remember that. I don't recall that.
It wasn't that he didn't remember, it's that he
Mr.
didn't remember it
McCullough
differently.
said, I'm going to go back to meet the deputies. I'll be right behind, and he said, I'll be right behind you. I don't remember that. The deputies testified, and by the way, just to clarify, deputy, maybe it was in the way I asked the question.
Yes,
but
it was.
I believe what I asked Deputy Walker was, were you aware, is it normal to try to get identity of a suspect? Yes. Are you aware that attempts were made? Yeah. They're all standing around there together. So he was aware of it.
I don't know what you were talking about there.
Said he spent hours. What's your name? What's your full name? We need all of your identifiers. And we need your date of birth. He says, the defendant says,
We can barely hear her here.
Forget my date of birth precisely.
But she lacks the passion for justice that should be present in her closing argument. It's almost like she doesn't believe her own story or the theory she's trying to say, happened. She does seem lost. She's rambling and wandering all over the place.
Answer again would be because he didn't want them to know their full identity for some reason. I don't know, but he was obstructing the law enforcement. They had no reason to make that up.
No, that charge was dropped.
I mean, if you believe the defendants and defense counsel, there's a big conspiracy going on
Her words, not ours.
between the deputies the CAD operators, I guess. Remember, he called a different agency. He called BIA, okay? He called 13 minutes after, when he already knew David McCullough was on the phone, back and forth with dispatch, because the calls kept being dropped. Well, they must have got those times together, whatever the heck that means.
She needs to have answers for this. She can't just present doubt. She should have a solid story that she can present.
And
that
where
will
was he
remove
going?
doubt.
When he ran into Mr. McCullough? I don't know. Why would he even put the wet clothes in the back of his truck instead of leaving them there? Why would he put this weapon that he had just killed someone with in self-defense in the back of his truck under his clothes? And that was the testimony also of David McCullough.
But David didn't see him.
That? No, I don't remember telling him that. And whether he remembers or not, Mr. McCullough remembers. Where was he going? And why, all of a sudden, after they went back to the port, they went back, when Mr. McCullough followed him back to the ranch to see what had happened, propped up against the thing when the deputies got there. It was propped up against the kitchen table. I'm sorry, it was propped up against the porch.
The kitchen table.
We don't know when he did that.
Where did that come from?
But he did, if you believe Mr. McCullough, who has no reason to lie, then he did do that after he went back and ran into Mr. McCullough. So where was he going to? Fleeing the scene?
After calling 911 and giving his name and number?
Now, again, he doesn't remember, conveniently, that he had this long conversation and then turned around to leave. Mr. McCullough said it was about 5 or 10 minutes. Then he turned around like a second thought and said, you know what, I'm in trouble. I need you to come witness the body. Not how somebody who just acted in self-defense against a person that he was supposedly friends with. Yeah, you can say the word devastated. And actually, Officer Walker did not say, he said he didn't remember whether he was devastated, if he said devastated. And he pointed out that on the transcript, it said in Ottawa. He did listen to it again, he said, yeah. He said he was devastated. But listen to it, does he sound devastated? Does he act like he was devastated when he talked to Mr. McCullough?
She's impeaching her witness
Mr.
in
McCullough
front of the
did
jury.
say to dispatch, oh, the guy here, he's fine. He's a little shaken up, but he's fine. He's calm. That's what the testimony was. And then he gets up here and says, well, I was in shock. I was in shock. I was in shock. That's why I couldn't remember anything. I was in shock. So I didn't tell him of this stuff. He was cleared, medically cleared twice that night. And remember, David McCullough just happened to be a retired physician's assistant. Don't you think when dispatch asked him how he was, he would have said, he seems like he's in shock. I think you need to get an ambulance. And don't you think if he was really upset enough, or he was hurt to the point that he had been sprayed with something and he had been injured somehow, don't you think instead of ignoring the question of do you need medical attention, he would have answered? Unless you want to believe that Officer Crespin was lying about that too. So far, 2 sworn officers lying for no apparent reason.
Her words, not ours. One more time. I don't know why she's emphasizing those words.
Instruction on credibility. But first, let's go through these red herrings. Because contrary to what Ms. Moss told you, I was watching the same trial. Believe me. Everything that they talked about,
Look at her body
for the most
language.
part, is a red herring. And you know why? Because they don't want you to look at what was found at the scene, what wasn't found at the scene, and they don't want you to use your common sense. Because if you use your common sense, I mean, make no mistake, ladies and gentlemen, the only reason that this alleged encounter with Drunk Guillermo on a horse, which came up for the first time when he testified here, why is that relevant? You know what it's for? To make the victim look like a bad guy, a drunk, a fallen over drunk. That wasn't even at the time of the incident. Why was that relevant? Why did they bring that out? It's a red herring. Fatty liver. He had fatty liver. He must have been an alcoholic. No.
Fatty
Dr.
liver?
Gerald said it could be from other things.
Well, that was the autopsy.
Obesity, not just alcoholism. And she said alcohol use, not abuse.
Although everyone testified that he
it's
was drunk
great
all the time.
That the neighbors in this neighborhood frackle or whatever happened there, but they can get up there and tell you what happened. But you know, with neighborhood disputes especially, there's always two sides. Unfortunately, Guillermo can't come and tell you why he sprayed. If he thought he was in danger because there was more people around him than he had. And he sure as heck didn't go get a weapon to shoot his neighbors with or to defend himself with.
She would have been better served to pick up the actual gun at that point, not the fake one.
And if you were paying attention, and I know you were,
Churchy.
the times when I would ask him about things that don't make his story make sense, like the time, why didn't you call that? I don't recall that. Why did you say it was poison and not a neurological gas? You never said race, so I don't understand that. Why did you, for 2 hours, refuse to give you a correct DOB? Well, I didn't do that. Why did they do that?
Have you guys
And
ever seen a police
actually,
officer ask the same question for 2 hours? That seems hard
two
to
different
believe.
magazines. He said he had a lot of magazines there. He was staying there. What is the big deal about 2 magazines? We know, he admitted, he even put the weapon there for them to see. The only magazine that matters is the one that was in that gun. And the only 2 rounds that matters are the 2 that hit Guillermo. In his head and his chest. And that's what he doesn't have an explanation for. He doesn't have an explanation of all the time that went by. He can't account for it. So then he said, well, I can't remember. I can't remember. The times might have been wrong. Residue or spatter on gun. That's it. Talk about speculation. That could
Only
have
it's
been him
there.
washing the blood off the gun. Because if he was that close to Guillermo, he shot him. You see the amount of blood that was there. And he was really at his feet. There would have been blood on here.
No. That is absolutely wrong. And hopefully somebody on the jury
And
has
the
fired a
reason
gun,
he
and
asked
maybe in
you
a
to
hunting
look so
scenario.
carefully
That is not how it
at the
works.
canister is because it's clear. You don't need an expert to tell you. Look at it. Look at the picture. Look at the picture. It's common sense, ladies and gentlemen. You canister was sprayed that day. But of course, I don't really know. He never really said whether he was sprayed or not. He was, he wasn't. He was stuck with it. He was only glancing below. Maybe he was sprayed on his face, and that stunk for a while. The mace wasn't sprayed.
Definitely not in testing.
And there is no explanation for why. If it was happening like Guillermo, like the defendant says, and Guillermo striking over and over and over again,
Stephen,
why, if you wanted to attack him,
we've all got the same question.
surround and use the mace? Wouldn't that get a lot more effective than just trying to hit him with this light plastic thing? I mean, seriously.
I hope this thing goes off. Oh my goodness, I hope it goes off.
Seriously. And if the struggle happened where he said it did, when he was first pushed down, he's the one who grabbed that weapon. He's the one that introduced deadly force into this altercation, not Guillermo. Mace is not a deadly weapon under any interpretation of the definition that you've been given. Not cause death. There's no reason to believe it would cause death, great bodily harm, permanent or prolonged.
I'm glad we have the audio of her hitting herself in the head with the mace can.
Didn't happen. And I suspect that's why after he realized that, oh man, I put that can backwards. I got to come up with a reason for that. So I suspect that's why the story he came up with was that he was hitting me over and over like this.
So now they're presenting that he planted that.
Doesn't make any sense.
There was
It's
no
not
evidence
reasonable.
during trial that that was planted.
And I say briefly,
I don't think she has a time limit right
and I'm
now.
not going to dwell on it, but I just know sometimes it's easy for jurors to get distracted by things that don't matter. The drama that you might have, tension you might have seen between counsel, it happens in trial. Don't let that impact your decision. Either way, it happens. I have tremendous respect for these two ladies, and they did a hell of a job defending him. But common sense does not go away. Look at how many instructions tell you
She's
to
praising the
look
defense.
at reasonableness or common sense. The ejection patterns, what would that have told you? There's no alleged encounter with the horse, the fatty liver, jump. Oh, even
She's
some
reading
more
through her
red herrings
notes.
today. They want to attack Mr. Walker, jumping from agency to agency. What's that about? Doesn't even know when the sun set. Oh my gosh. Shooting reconstruction. That was.
She's scribbled notes during the defense closing, and she's just reading off her notepad.
Here's the real thing, though.
You nailed it right there. Madib.
To believe that a struggle happened in that little house where Mr. Adiola, for some unknown reason, and I guess they want you to believe that he's drunk all the time, and he's high on coke all the time, and yet he never exhibited this behavior before to them.
Your Honor.
Here we go. I move for a directed verdict. As soon as she said that, never exhibited before, she basically broke the rules by basically saying what the things that happened before, the prior stuff that we have not been allowed to bring in, she's acting as if it never happened, and there were priors. So she says he's never exhibited this before, and he's got convictions for it. Now we've got a problem.
Yes. All right. Apparently, I'm out of time.
Got so much more to talk about.
But here's the bottom line. Here is the bottom line, ladies and gentlemen.
there's still a chance for this mace can to go off in the courtroom. Oh, shoot. We're going to wave the gun around some more.
He used this to allegedly repel this. You can't use deadly force to repel non-deadly force. And there's no way any reasonable person would have reacted the way he did on that night. I ask you to go back and deliberate with your fellow jurors.
Look for some evidence.
And I know you were paying attention and know you took notes. Compare your notes.
Take a
And
long
ask
time.
yourselves, what makes more sense? Did he act like a person? Whether testimony, action afterwards, what have you, that acted in self-defense as someone he knew that was a friend? Or did he act like someone that knew he had killed someone without sufficient provocation and without being faced with deadly force? Thank you.
Yeah, she was way over time.
Ladies and gentlemen, jury, this is a little different than pre-COVID times. In that in pre-COVID times, we could send the jury to that jury room to gain deliberation. What we'll do is, I'm going to have everyone exit the courtroom with the exception of the jury. Right? Your entire courtroom will be a courtroom for your deliberation.
What?
What I'm going to do, let me read this instruction, and then I'm going to tell you the procedure that we need to follow to do that, okay? I will not ask you to retire between your deliberation. You will be provided a copy of the jury instructions and exhibits, instances, evidence will be made available to you. Prior to beginning your deliberations, you will need to select one of you to act as foreperson. That person will preside over your deliberation and will speak for the jury here in court. Forms of verdict have been prepared for your use, and they read as follows. We find the defendant, Dean Cummings, not guilty of second-degree murder as charged in count 1 of the grand jury indictment. We find the defendant, Dean Cummings, guilty of second-degree murder as charged in count 1 of the grand jury indictment. We find the defendant, Dean Cummings, not guilty of voluntary manslaughter as charged in count 1 of the grand jury indictment. We find the defendant, Dean Cummings, guilty of voluntary manslaughter as charged in count 1 of the grand jury indictment. You will take these forms with you into the jury room. The jury room will be this whole courtroom. When you have reached a unanimous agreement as to your verdict, the foreperson will sign the forms which express your verdict. You will then return all forms of verdict, these instructions, and any other exhibits to the courtroom. What I'm going to do, I have good news and bad news for two of you. The good news for two of you is you get to go home right away. Well, not right away. I need to explain something to the two of you. The bad news is you've been here 6 days or so, and you don't get to decide the case.
Yeah. They need to go.
The two jurors that are the alternates are Catherine Maestas and Charles Law.
Surprised you used their names, not jury numbers.
Jurors, and what I need to do, folks, though, is I'm going to have everyone clear. I'm going to tell all 14 of you, go take about an hour break and come back. When all 14 of you are here, I'm going to release the two alternates. The reason I'm not going to let you go right away is that if something happens to either someone else, then I need 12 people to deliberate. So instead of holding you here while we clear this courtroom and the like, I'm going to have you go ahead and take an hour break. Come back in an hour. Once the 12 of you are present, I'll release the two alternates, and then I'll ask you to start your deliberations. All right. So go ahead and be back be back about 1:15, and then we will take a break. It's already 12, around 1:15, and we will recess early this afternoon for those people who need to go vote. Any questions before we break? All right.
Okay, so I didn't follow the time schedule there. It said 1:15. I think it was 1:15. Okay, we've got a little bit to talk about here. Some of you had some questions we weren't able to address as this happened. I'm going to keep the audio on just for a minute here, even though we're going back to my camera. I can do that here if I hit the right button. Okay, so we're still hearing the audio from the courtroom just in case they still do something after the jury's gone, but I don't think they will. So yeah, it's bizarre. He said it because of the health protocols, the reason why they're all wearing masks in New Mexico. They don't use the jury room because of the tight quarters of the jury room for deliberations.
And everyone else, I'm gonna need for you to clear the courtroom, take all your belongings with you, including our cameraman. You'll have to take the camera. We can leave the tripod there, but take the camera off. And then, counsel, leave your cell number with Audrey and be after.
Cameraman's like, please, can I stay? That'd be great.
Be within 10, 15 minutes of the courthouse, okay? All right. We'll be in recess until then.
Okay, so camera's going to be broken down. Tripod gets to stay there. Camera's.
She has my cell phone.
Yeah, just give it to the number in front of you.
We'll just give it to you again.
I know I have John's.
And then we need to go get a laptop.
You have to.
I just want to listen to this hot mic scenario.
Do like 20, 15 minutes, 15 minutes. The reason I say that is once we get a bird, by the time we round, everyone has to go. Okay. I'll take your camera off. Just your camera, everything. Yeah, but no audio. No audio. Okay, no, you can just take your camera off.
Okay, I'll just take it off. Can I set it on the floor?
That's the cameraman.
Because there is no audio. I'll unplug it.
Yeah, sit on the floor.
Okay, take it. Okay.
Cameraman's like,
We can't use our jury room now.
I understand that.
okay, so they're just going through the process of clearing the courtroom. Cameraman's going to unplug the camera right here. We're going to lose. Oh, yeah, we're losing audio here. He's taking everything off. Yeah, this is like a butt dial, the courtroom version of a butt dial on your cell phone. So there were a couple questions. If you've got a question that wasn't answered,
When they come back to the hungry, we'll ask them. Okay. Because it takes forever to clear. Yeah, but everyone.
there's a lot going on for being off the record. Yeah, the video is still just showing the eagle on top of the flag. There's nothing to see there. It just looks like this.
I've seen him lose. I've seen jurors lost during a break. What?
That's not an exhibit. Yeah, he just told me I could. It's not an exhibit.
The defense just said, "Can we get this tape, this painter's tape, off the ground? It's not an exhibit." And the judge is like, "Sure." The defense starts tearing it up, and the prosecution's like, "Hey, what are you doing?" He's like, "It's not an exhibit. He told me I could." Because that'll be gone now in the room that the jury's deliberating in.
You can leave that here. If I say for the
I love this cameraman. Love that he left the mic hot. Wayne, they better not leave the mic on when the jury's deliberating. That's going to be in an hour. They've got lunch for an hour. Okay, and here goes the camera.
Yeah, or be available around. You don't have to be back here, but be available around.
Can we leave these in the courtroom?
Yeah, but, I mean,
I should get phone numbers.
Okay, So we just lost our feed. Okay, so that was bizarre. Oh my goodness. Let me show you what just arrived. A ham sandwich. Thank you very much. I appreciate that. I'll give you my empty hot chocolate mug that I did not spill on the laptop. And we're going to answer a couple questions before we tear into the ham sandwich here. See, I wonder if they leave the hot mic on while the jury deliberates. No, the camera is going to be off the pedestal. It's disconnected now. It will not be plugged in again until after the jury's done deliberating, really. And that's going to start in it. Well, it won't be plugged in again until an hour when the judge tells the jury go ahead. We might get to see that. I'm not sure. So if you had a question that wasn't answered, if you were confused about where we were at or need a background covered during this little break here, before we break, put my name, tag Recovery Addict in there. It shows up in bright orange on my screen when you do that, and I'll be able to find it. Okay, Tammy Christiansen says, does failure to collect evidence violate due process? They conveniently skipped anything that could be exculpatory. It definitely does not help them at all. The fact that they didn't do things that could have proved his innocence does look bad on them. But they also missed the things that really prove their case. They don't have evidence to prove anything. All they've done is been able to find alternate scenarios that might also work with some of the evidence in different situations. But it's not very clear. It's not very clear, so that they have to make this different idea for what happened or why the evidence is where it is. Why is the heater on the ground or why are his sunglasses on the ground? He might have just set him there. It's like, yeah, he might have, but people don't usually just put their sunglasses on the ground. Why is the heater on the ground? Oh, he might have taken it off on purpose. Yeah, but why? It seems unreasonable for the explanations they came up with. They really should have done a more thorough investigation if they wanted a conviction here. Did the heater fall during the night and Dean woke up to a propane smell? No, Dean testified that he wasn't using the heater. But he did have that propane smell. Not sure about that. Let's see. Your back is to us, says Bella. I am sorry. I don't mean to be rude. Let's see here. It's like 6 different button pushes to get it fixed. There we go. Bella, thank you for telling me. Let's see. Pickle? Yes, of course, pickles. The prosecution present any evidence other than speculation? I missed some. No. There was all speculation. They were the ones that introduced doubt into the whole scenario. The best they could do is their version of events, which is questionable, and they don't have a complete accounting of it. Is introduces doubt and tries to say, oh, that's not what a reasonable person would do. But the way that Dean explained it, it sounded very reasonable and logical as he worked through every single step of what happened. Hang Fake 44 says, I'd cut that sandwich in half diagonally. I used to be a big fan of diagonal cut sandwiches. Now I like having the whole sandwich in my hand. I know where it's all going to end up. I don't have to cut it in half like I'm only going to eat part of it. Let's see. They both graduated from Fred's Law School in tire care. It's an online class, right? Let's see. Yes, pickles on the sandwich. How can you have a sandwich sit in front of you without sneaking a single bite? I could not. Well, AJ, here's the reason. I know it will not look very good on camera. The optics of me eating the sandwich on camera will not look good. There will be mustard all over my face. There will be crumbs. The audio that you would get from that would probably be enough for you to just unsubscribe right then. So I'm gonna hold off on the sandwich just for a little bit. Abby wants us to vote on how do you cut your sandwich. If you cut it at all, right? I'm in the no cut category. They tried to do a snidely whiplash towards the end. Yeah, they tried to throw some stuff in there that was just bizarre. They waited till the very end to allege that he had really planted this mace container, which they already tested and didn't have any of his DNA on it. And yes, mace in and of itself may not be considered a deadly weapon, but the fact that you have a drunk guy on drugs who's said, I'm going to kill you, and that is attacking, and mace is part of his attack, and he's not stopping, it's continuing, and he's feeling threatened, and he's trapped in a corner, he's worried for his life. I think he met those standards, because once you're sprayed with mace and just debilitated, then you're suddenly much more vulnerable. And he saw that was where it was going, I think, and and acted appropriately. Yes, please be safe down in Florida. I'm going to take a look at the map here. Let's see. Kay Dunlap says she never finished full scenario. It's like her thoughts interrupted her thoughts. Yeah, she had a notepad, one of Daryl Brooks' notepads, I guess. I don't know, that that was sitting in front of her, and she had written, just scribbled little notes every time there's something she wanted to address. And she brought it up as if that was the point, but then didn't have anything to say about it. So she was just reading her points of what the defense had made a point about, and then going like, really, I guess if you believe them, who knows? But yeah, I think the jury believed him. I think that's where we left it. I'm just checking on the satellite imagery for the weather on that. Is it Hurricane Nicole yet, or is it still a tropical storm right now? Do we know? I've been so busy with you guys, I have not followed. Ooh, it's not looking good. Okay. I'll have to get a different map of that. Mayo or mustard? Both, actually, Charlie. Great questions. We ask the big questions. Yes, TD or TW, you're right. It made no sense. The stream of consciousness is not your friend as a prosecutor. Yeah, it was, for lack of a better term, just verbal diarrhea. That was, it didn't progress. It didn't, convince anyone. There wasn't a logical progression that we followed that would help us reach the conclusions she wanted us to get to. I carry pink mace too, says Lori. Yep. It's probably dye. It probably has dye in it, right? Now we have red herrings, fatty livers, and subject matter jurisdiction. We'll add that to the list of things for the merchandise. Okay, we just got audio from something else. Hang on. That was weird. Okay, so that was courtroom audio. We shouldn't be getting that. I turned that off. Let's see. Mostly because everyone's gone. Everyone's left the courtroom. It's going to be an hour before they're back. Who is the better lawyer, Daryl Brooks or the prosecutor? That is a toss-up. Maybe we should do a poll on that. And Miss Chris says, love the hot mics. Yes, that's when you get all the good stuff, the juicy bits of information, and sometimes people's cell phone numbers. Evil prosecution laugh. I was hoping the cameraman would do that. Go back. You guys want the audio again? Let's see. Nope, there's no feed. I'm watching the audio meter, and even though I've got it turned off, I can see when audio comes in, and there's nothing coming on it right now. Book Hermit says it's illegal to carry mace here in Australia. What do you spray your neighbors with then, Book Hermit? I'm very curious. How do you greet your neighbors if you don't have mace? We are nosy. We like to eavesdrop. We do. It's a guilty pleasure. We like to hear what's going on behind the scenes. I might change my name to Fatty Livers. It sort of rolls off the tongue, Stephen. It's really it, and it's got this mental image that goes along with it. Abby's shouting out my Facebook page. I don't do much over there right now. It's been a while. I did try to live stream, co-live stream yesterday's feed. Didn't get many hits on that one, and it was just slowing down this feed. And I'm like, this is the one I'm having fun in. This is where I've got the chat that we interact with. So if you do want to follow me on Facebook, if that's where you're at, that's a good way to reach out to me and contact me, either through Facebook Messenger or through one of my posts there. I probably should do a little bit better with that. But that's one more way you can reach me. If you don't want to call the hotline number, which is always available 24/7, Recovery Addict Hotline, it is the burner phone, 801-513-1160. Give it a call, leave a message, send a text, send a picture. We'd be glad to put you on the air if you meet all the terms and conditions. We wave and say good day. No mace. Book Hermit, you guys, you Aussies are just a weird bunch. Clearly you're not doing it right if you don't have mace. Abby says, thought we could use your Facebook page as a family chat meetup place. Yeah, and maybe the notifications on there go out a little better than on YouTube. Maybe that's an option. Thank you, Patty. Appreciate you following me over there. Let's see. Super soaker full of Tabasco. Oh, man. That's pretty good, Charlie. Why was she hitting her head with it? This is a great question. She's got the mace. This canister arguably still has mace in it, right? It has not been used since it was last sprayed at Dean Cummings. It was from the crime scene. They have not tested it. They have not sprayed it. No one's checked it. It's still the same whatever chemical it was in it that he got sprayed with, and the prosecution is like, lifting, to use this mace you have to take this and lift up the lever and you put your finger here. I'm like, do it, please do it. Oh my goodness, I would have paid good money for her to just clear out the courtroom, spray mace, see how long it lasts in the courtroom. Thank you, Abby, for posting the burner phone number. I'll have to make you a little video or an image, an overlay with that. So you don't have to do the copy and pasting, but I do appreciate you doing that. You've been, you, Chandra, Churchy, all of you guys have been absolutely wonderful moderators. I appreciate you being here. It sounded like hitting an empty tin drum. Lori, the echoes, that was was phenomenal. Please add your socials and Matt's in your description box, Churchy. I will work on that during the break. I hesitate to do that while we're live. Just because I can't talk and type at the same time, and then you guys just get me staring and hear click, 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 click as I type 1 word per minute. Mr. Upper Torso says, my biggest wow was when the prosecutor acted out the attack Cummings described. Even if she's trying to make it sound silly, it just paints the image for the jury. It did. The jury now looked at it and was like, hey, yeah, I see how that happened. He described that pretty well. Seven says, this channel is great. You guys make it amazing. I appreciate you guys being here. We need to sue these prosecutors for prosecutorial misconduct. Oh man, how is their career looking? I mean, how's that promotion? Is that coming? Can you imagine one of these becoming a judge? Oh, that would be crazy. I almost spit out my coffee when she did that. Yeah, it could have gone off. It could have gone off. Okay. Now we have a problem. I have a very full mug of hot chocolate. I think my wife secretly wants me to get a new laptop. This is the only thing I can really safely assume from this, because she keeps giving me, knowing full well that yesterday I spilled a full mug of water on my laptop and the keyboard is still not really working as a result. The screen even shut off and came back on, and shut off and came back on during the live stream, I might add. But knowing full well that I did that, she keeps giving me cups of liquid to have next to the laptop. So I don't know. I guess I get a new laptop. Merry early Christmas to me. Does that work? Okay, so now I need to use the mouse right next to the mug. We're gonna put this over here. Okay, it's safely there, and I'm not going to touch it until until we're off the air. I do need a lid for that. We need to make a special sippy cup lid for these mugs. I remember the same, act out the attack during the Danielle Redlick trial. Spoiler, she was found not guilty. Right, I can imagine that if the story really was outlandish and had components in it that were just very hard to replicate. Yes, Lori, I am. If the story was very hard to replicate and just, it's like you can't get to point A from point B the way you're describing it, then having them act out, that's going to serve well. If the defendant is, if Mr. Dean happened to be like a 75-pound boy or something, and it's like, it just doesn't fit the image, clean cut, smiling, rosy cheeks, just doesn't fit the image of a murderer. It might be good for the prosecution to have him acted out to have that gun in his hands, so the prosecution can put the two together visually and say, I can see him now holding the gun. I can envision that. And that could be what they were trying to go for, but it really did backfire on them. Somewhere in southern Mississippi, there's a 7-Eleven with a prosecutor's name on it. Oh, man. Because of how bad the prosecutor did, she made him seem believable. She did. Even if you wanted to hate him, his behavior versus hers just made you say, well, maybe what he said is true. Completely. The wife is a keeper. I am blessed beyond what I deserve. I married up for sure. I'm so grateful I've got her. Mom says, I need a new laptop. I just like trying to decide what I want. Momson, I went the Apple route a long time ago. Not because I think they're better, because I used to do PCs, and I've even built my own PC in the past. And I like that. I like the gaming side. I've told you that. I was addicted to gaming for a while. And I do like PCs for that. But what I was doing when I was buying a Mac was very heavy on the video side, and Macs are better at video editing than PCs. And so I bought into the ecosystem, and I found it very hard to get out of. So choosing to decide a computer, for me, if I buy a PC, I suddenly have bought one piece of hardware that doesn't play well with everything else I have. So I don't think I can ever escape. I will just forever sign over every check I get to Apple. Good thing they didn't act out the DB case. Oh, my goodness. Let's see. Bella says, I want to marry up. Highly recommend it. Highly recommend it. Shauna says, I live in the middle of nowhere. My internet has been so aggravating. I know I'm missing so much today. Can't see much of chat. I'm sorry, Shauna. Hopefully the replays will help out. Donna's a hardcore gamer. Good times on World of Warcraft. I've been there. Definitely been there. Yes, he may be addicted to those, but names come from metal detecting addiction. Yes. For those of you that have stumbled on this amazing channel full of amazing people in chat, the name that I chose was because I'm addicted to recovering artifacts in the ground. I love metal detecting. It's like dirt fishing. It's fun. It's a discovery. I'm not the guy that saves everything and hoards everything and has rooms full of artifacts. I just like to find them and usually give them back to the landowner as something cool they can keep in their, on their wall or something. But I'm addicted to the finding part. Lori says, I definitely married up. Best friend, buddy, hubby, father. Wonderful. Good to hear. Okay, I'm back. Windy outside. Looked at the storm track. Should be an update soon. And keep us updated on that. Hopefully you guys are all safe. What is I haven't seen on the National Weather Service. What's the category right now? What's the forecasted intensity when it makes landfall? I know it's going to be wet. Okay, but and I'm going to answer that one if you want to, and then we're going to do this. Yep, we're going to play the music because it's lunchtime. I have a sandwich here that is begging to be eaten. You actually watched my metal detecting videos a while back. They're pretty boring if you're not there. For me, it's fun, but I love it. Let's see. I did not realize I married up until years after marriage. She's still here. Wonderful, TW. That's good to hear. Cat 1 at landfall. That's better than the Cat 2, but still, that's a lot of wind and a lot of water. It's going to be wet. That's what she said. Okay. Yeah, thanks, Upper Torso, for going there. Teal block, please. We're asking for teal. Let me see what the music is on teal. Boom. Which one's teal? Okay. Oh, the one we played before? You like that one? I'll fade this one out here. Hang on. Okay. We'll get teal instead. This is teal. Okay, thank you guys. I'm gonna go right up. Man, we've got a bot in here right at the very end too. I'll see if I can get this one. Report. Explicit. Gone. Okay. Appreciate everyone. Feel free to share this stream if there's somebody out there maybe on your friends list that might fit well with our group. We'd love to have some shares and get some more input from different people. My favorite's the video of the $5 coin. That was my favorite find by far, Roxanne. I love that one. Okay, hot chocolate. I'm going to drink this away from my laptop. We'll be back for whatever this case brings us as soon as it does. So I'll do some research. Does anyone know what time it was? He said 1:15. I think we got about an hour. I'll put a timer. I'm going to put about 45 minutes on the timer. We might have some time to chat before we get any video and stuff going. Might take a look at some of the other court cases that are going on. Let's see. So that timer is up. Is that working? Let's see. Let's turn this one off. Turn this one on. There we go. So timer's working. I'll keep that going. 1:15 or 25. So 25 minutes. Serious? Okay. If it comes back early, I'll be here. As soon as the feed comes in, we're going to be live. But 3:15 our time, that gives me 20 minutes. Man, okay, make your sandwich, get your drink, give everybody a hug that you love. We'll be back in a little bit, and thank you all for being here. It's wonderful to be here with you guys. It really does make my day every single day. Appreciate you guys. See you in a bit.